What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
How dare you?
Going to be the theme of the day today. Good morning, good afternoon, good evening, everybody. Hi, welcome to me, Legal Vices, on my little channel I like to call Legal Vices because I'm creative like that. Whoever you are, wherever you are, whatever you're doing, however you're doing it with, etc., etc. I'm just glad you're doing it here. We got a lot of ground to cover today in relation to the Maya case. So without further ado, as the Canadians say, let's bring up Megan Fox. Good morning, evening.
Good morning to you. It's evening where I am on the East Coast of the United States in Maryland, having Thanksgiving celebrations with Stephanie. I am in her office, my sister. So, hey, everybody.
How's the Yoldi Thanksgiving holiday weekend thing going?
Well, Mr. Fox had to stay home because he got a terrible outbreak of the shingles right before we left. And so he stayed home to sleep, and he is sleeping. Everybody else is doing okay.
Go visit the family. Oh, shingles. Oh God, I gotta stay. Oh, the shingles again. Just how coincidence.
Yeah, well, he did. So the kids are all at a movie right now. Little one is downstairs. I've set him up with a movie, so hopefully he won't be in here bothering me every 5 minutes. We'll see.
Right. So. Wow. This is something that we didn't plan on doing until we started reading it, and we thought, yoink. This is something that we need to get here and look at this, because the defense, as I'm sure most people know already, because a lot of people have already covered it, have filed a motion. They've filed a motion for a new trial. And they're blaming juror number one. The Dick defense has filed a motion for a new trial based on juror misconduct.
Yes, and for those of you who don't know what case we're talking about, it's the Maya Kowalski case. And Jay Hatch, what I've been told, Jeff, is that hospitals do this kind of shit all the time to people. They're ruthless. And we just got lucky that we're able to see it happening, that it's happening because there's such public interest, and we're able to actually get a look at these motions. But this is something that's really commonplace, which really hurts me deep inside. I feel outraged. Yeah. I feel enraged by this.
Well, I mean, reading through, and we're going to read through as much of this as we possibly can. We're going to have to skip some parts because it's like 40 some odd pages long. It's like you vacillate between just outright anger and rage, and it's like a 50-50 split. And sometimes you're angry, sometimes it's hilarious, and sometimes weirdly it's angry and hilarious at the same time. It's a ridiculous motion, and Megan has got her little foxy paws on another 100-page motion they've just filed today.
Yeah, and I wish we could go over it, because that one has made me even angrier than I can even. I didn't even know I could be angrier at Johns Hopkins legal team, but I'm even angrier. The second motion they filed, so this 100-page motion now, it is a motion for a retrial on every count, that they don't get thrown out on a directed verdict. So if they want the judge now, Judge Carroll, this is not an appeal. This is going to Judge Carroll to say, the jury got it so wrong. We want you to overturn the jury decision on all of these counts. And if you don't do that, we want you to issue a remediator to knock down the awards, because they're far too high. And if you don't do that, we just want to retrial on the whole thing. It's insane. It's 100 pages of insanity, Jeff. And on page 59 of this thing, they admit that they put her in the 48-hour surveillance at the behest of Sally Smith, which is what they said they did not do the entire trial. They
Yeah.
said they did not do that, that it was for medical purposes. Well, now in this motion, they're admitting there was no treatment. They even say it was not for treatment, but to see if it was a test to see if she had CRPS symptoms.
Yeah.
What? It's
And
bad.
well, these are the same people that wouldn't say that Sally Smith telling someone to stop someone's medication isn't medical treatment.
Right.
Yeah. That's somehow not medical treatment.
It's very bad. They also called the jury in the 100-page motion. They said the jury were too ignorant to understand.
But see, that's the thing. If they're too ignorant to understand, the failure to explain it to them in language that they can understand and apply is the lawyer's fault. That's why my torts teacher, who that's exactly what this is. It's a legal tort. It's an illegal act that caused damage. That was everything that was his favorite line in my torts class. When reading through the cases, he would point out a student and go, Jeff, for 1/3 of the recovery, what is your argument to the 6 ignorant slobs? That's what he would call the jury. He would call them the ignorant slobs. Because they don't know the case histories. They don't know the legal side of things. And that's your job as a lawyer to explain it to them. Any failure is not the failure of the jury. It's the failure of the lawyer to explain it to the jury.
I wrote down this one quote from it, and this is just one of the times they insult the jury. There's several others. But listen to this, Jeff. The jury clearly did not understand the nuances of immunity under the instructions given by the court. The limitations placed on this issue made it impossible for the defendant to keep the jury from being enraged about events and circumstances over which the defendant had no control and no legal responsibility. No, sir, we are enraged.
Read that first part again.
The jury clearly did not understand the nuances of immunity.
Okay, right there. The jurors clearly did not understand. These ignorant jurors, who put those ignorant jurors on the stand, defense lawyers? You and the prosecutors agreed that those were the lawyers that you wanted. You picked those lawyers. Sorry, jurors. You picked those jurors to be on the stand.
We did.
You picked those jurors. Now you're saying you picked ones that were too stupid? Well, you picked them.
And if this is their argument, that when you get a verdict that you don't like, that you can go to the judge and whine and cry and say, but Your Honor, the jury was too stupid and they didn't understand. And you can get the judge to overturn the ruling of 6 people. Then why the hell do we have a jury system at all? Why did you drag those people out of their lives for 12 weeks to sit there, get no money in return, get nothing out of it but being harassed now by the defense? The Dick defense is now stalking them, stalking their spouses, doing all this shit to them. Why would we have juries if a judge could just go, yeah, you're right, the jury didn't get it, they got it wrong, I'll just make it all go away
thankfully,
for you.
That's why thankfully it's very, very difficult to overturn a jury verdict.
They want they want Judge Carroll to do this. What are the chances, do you think, Jeff, that Judge Carroll is going to be like, oh yeah, sure, yeah, okay, I'm going to overturn the verdict of this jury?
Yeah, I mean, it's easy to not get it's easy to get someone not selected for jury duty. You can say, I don't like the color of this guy's tie. You're out of here. Once you seat the jury, it's very difficult to get a juror off the jury. And once the jury has made a decision, it's even more difficult to backtrack and go, but we didn't like that one. We want another decision. But they're trying that today. They're trying that in this motion for a new trial, specifically blaming the conduct of juror number 1. And we need to dive into this. So let's read the things that need to be read here before we get going. Karate Cat Mom, hey, welcome. Thank you for being a new member. Thank you for joining. New memberships are always appreciated and loved and welcomed. Thank you. Deadshot Gaming, looking forward to tonight. Well, tonight is here, Deadshot Gaming. We are live. We are here. And Vodka Blood, a new member. Thank you so much for joining Vodka Blood, cute little doggo there. And Deadshot Gaming is also a new member. Woohoo! Thank you. Let's give it a whirl. I'm sorry, I'm still recovering from Friday night. Deadshot Gaming, thank you so much for joining. And Digger 420 member for 14 months. You're one of the OGs. Love you, Jeff. I got to miss this one. Don't Sabbath, but I'll be on replay crew. Megan, thank you for everything. Love to the Vices squad. Y'all rock. Oh, well, thanks. You rock too. You'll hopefully come back later and hear it. And Leaf Lover Liz. So excited to watch you two tonight. Husband and two toddlers camping in the backyard. Where are you living? You can camp in the backyard. It's like 25 degrees here or -3. And that's without the wind. I'd love to be camping in a backyard. Mama's alone. Yay. Let's get into it. Dark Black Hearts, shady ass defense. And Nicholas Starov's Trial Watch. JHatch is doing nothing without a direct order from the board of JH.
I can't believe they'd rather spend all this money. Imagine how much money it cost them to file a 100-page motion. How many hours went into that over the Thanksgiving weekend, by the way? They did this today. They were working.
That's going to be their next motion. That's going to be the next motion. We spend so much on legal bills, we can't afford to pay the debt. Reagan's got an article out here.
I do. I have a new article. I got a new interview with Greg Anderson, which no one has heard this statement before. This is brand new exclusive interview on pjmedia.com. The link is in that Jeff just dropped it in the chat. Please click on that. Help me to get that trending. Please share it on social media with everybody you know. But it's his response to the Tampa Bay Times that has come out saying that Johns Hopkins, you're going to love this, that Johns Hopkins All Prisoners Hospital could not possibly afford $261 million. It's going to bankrupt them. And they misrepresented the actual financial situation of JHatch. And Greg says he handed them a thumb drive, handed that reporter a thumb drive with all the financial information on it he needed. And he left all of it out and only reported what JHatch wanted him to report. So that made Mr. Anderson pretty angry. And I got to speak to him about that. So that's in that article. Please do. A 404 error? What? Hold on, please. Did I give you the wrong link? No.
The one you gave me earlier came up on my phone fine.
Well, I'll drop it in again, but if you're getting a 404 error, I think it's you.
I will click it and tell you what's going on here myself. Pervert church. Yep, it's you. It's loading.
It's loading. Okay. It should work for the UK. I have a lot of people who read me in the UK. All right.
All right. Well, let's read. Speaking of reading, Ginger with a Soul. Remember, for 8 months as I've been here since Depp, actually, back when Jeff could read the entire chat during streams. Yes, Megan says she doesn't want to get any larger. That is one of the drawbacks. You can't read everything, especially when you're reading something on the screen. You can't read chat. You have to trust the entire herd of cats to behave while you're doing something. That's why I'm happy to have one of the greatest chats on the entire internet. They manage themselves quite. Thank you and love you both. Here we go. Let's give it a whirl. Lost in Law -5 is the perfect camping weather. No bugs. Oh, I forgot to give people the bell rings. All right. Lost in Law -5 is the perfect weather for camping. No bugs. And Nicholas Starov's Trial Watch. Thank you so much. It is a risk/reward analysis, how many Maya is out there and how they can scare them away by showing what they need to spend to maybe get a dime.
Well, the Kushners are up next.
Correct.
The Kushners are up next. So they know there's more coming. And it's not just them either. There's at least, how many did we hear during the trial? 400 to 500 families that Dr. Sally Smith worked on with Kathy Beatty.
And the thing is, you get people like the good doctor and people that are willing to work for free. Some of the most qualified people in the universe are willing to work free for the defense. And you want to say prosecution, for the plaintiffs. Mm-hmm. You're looking confused, Megan.
Yeah, I was just someone was telling me that there's some extra stuff at the end of the URL that's causing the problem. I don't know what it is though. Sorry.
It comes up perfectly clean on mine.
I know it comes up for me too. Yeah. Anyway, You're right. When there's experts who are willing to work for free for your client, it should tell you everything you need to know about this. Not only did Dr. Corcoran work for free, but that guy, the other one who did was it the financial analysis at the end there? He's one of the last. He did it for free. The yacht father did it for free. So that's 3 expert witnesses they had who actually worked for free. Dr. Corcoran had never been an expert witness before, ever, ever. He took a chance
Right.
that he would be blackballed from the medical community for going up against Johns Hopkins to do this. This should send a message and should tell you who's telling the truth, but I think you all have figured it
Yeah.
out.
And our last super chat, then we're going to dive straight into this, is from The Chugi Show. Just want to wish you a belated happy Thanksgiving. Thank you so much for that. And a belated happy Thanksgiving to you, too. All right. Before we get going, there is one caveat. There's one thing that I have to say. I know a lot of people were redacting the names of juror number 1 and Mrs. Juror number 1. I'm not doing it. One,
We're not gonna do
because
that.
it's like 100 times listed in this thing and about a bajillion times in the exhibit. Don't have time for that. But also, they were the first ones to out themselves. It's
Yes.
not doxing. They're the first ones that put out who they are in a very, 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 very public forum. This is one of the exhibits to the motion to dismiss, and this is on the Facebook group Take Care of Maya. This is how they came out to the world here, saying your greetings
With their real names.
Yeah.
So, and their photographs. So they were not worried or concerned at all that people
Not
would
at
know
all.
who they were. So we don't need to be worried or concerned
Yeah.
that that their names are out there. We just don't need to. And anybody who says that we're doxing them, you're just plain wrong. Not to mention that this court document is public. It's on the public
Yeah.
docket, and the clerk did not
Yeah.
redact it. So just please, everybody calm down. Nobody's getting
Nobody's getting
doxxed.
doxxed. Yeah.
They put their own names out there.
Yeah, I mean, you can see this is on the Take Care of Maya Facebook group. Paul Lengill, greetings, juror number 1 here. Not now being the day after, Yolanda Lengill, he's my hubby. And here's his picture, and
She's proud of him. She's proud
Yeah.
of him. She's proud of her family. She's proud of what they did. So it's fine. It's fine.
So chill.
Yeah, everybody chill out. It's like, so yeah, calm your tits. Somebody, I posted a screenshot on Twitter and someone was like, "Oh, great journalism work, Megan, doxing these people." And I'm like, it's on a public docket, you moron. Anyone can
Yeah.
go and get it. This is not the definition of doxing. There is no address on here. We already went through it and looked. So
Yeah.
I heard you guys think that the defense put their address in there. We haven't been able to find it. So
Yeah,
I
I've
don't
been
think
through it
so.
twice and I didn't see it. But even if they did again, public document, meh.
Again,
So
that's
anyway.
public information. We're not trying to do any of that, but
Yeah, and I mean, we're not going to go out of their way because it's a weird name for me to pronounce anyway.
we're just going to call them Mrs. L and Mr. and
Yeah.
juror number 1. Okay.
Yeah.
All right.
Okay, this is it. This is the 39-page motion. Let's jump on in here, and everybody, the 600 people that are here now, thank you so very much for being here. Please, while we're doing this, hit the like button. Let's get YouTube out there to put this on the algorithm. Once we hit about 600 likes, we're like 400 away from that. They'll kind of put it out in the cycle, and that'll draw people in to hear this important motion. Please do that. And if you haven't subscribed, hey, give me a crack. Not give me crack, give me a crack at this. Take a chance on me. Take a chance. Chance. Let's go. Defendant's motion for a new trial based on juror misconduct. Motion for juror interview. Motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. Now they are having an emergency hearing on this emergency motion on Monday. I don't know if it's going to be.
I've been told it's going to be in the afternoon. It won't be Monday morning, is what I've heard. But then again, I don't know. It hasn't been set yet, but I've been told most likely not till Monday afternoon because they're giving the plaintiff time to respond. Clearly, plaintiff has not been able to respond. Everyone is at Thanksgiving. It's crazy.
Yeah. Well, here's a little bit of the background. Let's start out here. Defendant Johns Hopkins All Children's Hospital, Inc. They're big business. They're a big company with lots of money. And they are one of the most funded hospital networks on planet Earth. So don't feel too bad.
No, don't feel bad.
Through undersigned counsel and pursuant to rules, hereby moves this court for an order permitting an interview of juror number 1, opening discovery into evidence of juror misconduct, requiring the preservation of certain evidence on an emergency basis, and granting a new trial on juror misconduct on grounds set forth herein. According to the Florida Supreme Court, potentially harmful juror misconduct, including contact with a juror during a trial about the pending matter, is presumptively prejudicial. Just any contact of any sort whatsoever with any juror is presumptively prejudicial. That's kind of ridiculous.
All right, Jeff,
yes,
the chat is panicking because they say the address is in the very first footnote on this page.
Okay.
So when you get to the bottom,
I'll just skip right past it.
We'll skip right past it and then bring it back up. Okay. All right, everybody, are you calm now?
Do that.
Calm your tits. Calm your tits. Everybody, calm down.
Take a deep breath.
I knew they were going to do this. I knew they were going to do this.
See, that's a lesson you learn. Nobody ever reads footnotes. Like I've been through twice.
That's my sister does. When we were reading it, she was like, "Get to the footnote. I want to read the foot. That's where all the good stuff is."
Oh, well, we've already passed it. All right. We're not going back. Don't worry. And again, it's a public document.
Oh, well, you guys, calm down. It's a public document. It's on a public docket. Everybody's address is public. It's in every single everything you've ever filled out that's filed anywhere. And if I really wanted to get your address, I could. And if I wanted to publish it, I could. And it's not doxing because it's public. So just calm down.
Right. So anyway, we're moving on. We're not even going to entertain it anymore. That's not the point here. The point is what the hospital's doing.
Right.
A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced his case. So the jury does not have to. The party seeking to interview the juror, because that's the first thing they have to interview the juror. They don't have to conclusively establish that the misconduct occurred or that there was any actual prejudice to the case. Skipping through a bunch of these court quotes. Rather, it is only necessary that the party establish a basis for an inquiry on grounds the party believes may exist. Once improper, and now I had to check the footnote so people didn't panic. Once improper contact or juror misconduct is established by juror interview. First of all, you have to establish juror misconduct through an interview. The moving party is entitled to a new trial unless the opposing party can demonstrate there's no reasonable basis that the juror misconduct affected the verdict. So what they're saying is that once you interview them, if you prove that there was misconduct, then the burden of proof shifts to the opposing party, to the party who wants the verdict to stand, to demonstrate that there was no reasonable possibility of jury misconduct. And a new trial based on improper contact may be required under some circumstances. Not is required under all circumstances. May be required under some circumstances as a matter of public policy for the purpose of maintaining confidence and integrity of jury trials. This motion sets forth reasonable basis for belief that juror number 1, the foreperson, engaged in presumptively prejudicial misconduct during the course of the trial by deliberately disregarding the court-specific instructions.
That right there, it's like, well, prove it. And I can tell you in this entire motion, there is not one iota of evidence of that.
That's the thing. That's what you were going to be saying after just about every sentence in this.
Oh, really?
Prove it.
Where's the
prove
proof?
It. Exactly. Yeah. See, it's a reasonable basis for a belief, not a reasonable basis that it happened. Not a reasonable basis. This is a reasonable basis for believing that juror number 1 may possibly have engaged in something. Mm-hmm. So he allegedly disregarded the court's specific instructions not to discuss the case with anyone during the trial, not to consider any evidence or information outside of what was presented during the trial, and not to form or express any opinion about the case prior to deliberations. Well, they're asking, how can they prove this? Well, they want to interview the guy and go, "Did you do this?" And he's going to say, "No." And
the judge is going to say, "Dismissed."
That may be a reason why this is scheduled in the afternoon. Just like, we can wrap this up real quick. Who knows? Weird things can happen. You can't ever predict what's going to happen in court. But This motion is supported by the sworn affidavit of Ethan R. Shapiro. It's like a 29-page thing. Attached here to is Exhibit A, the affidavit and evidence attached here to is Exhibit B, discovered by defense counsel after the verdict reveals potentially harmful and therefore presumptively prejudicial juror misconduct arising out of improper communications between juror number 1 and his wife, who reside in the same household during the course of the 9-week trial. A juror lived with his wife during a trial?
How dare he? So this is the thing, is that they're pretending that the wife also was under some kind of oath throughout this entire thing, and there's no rules that unless he's sequestered, he gets to live with his wife during the trial. Right?
Yeah, weird, huh?
So strange. This was not a sequestered jury. Civil trials usually are not.
Well, and criminal trials usually aren't either.
Right.
That's a very extraordinary step. So one, there's shocking levels of involvement in the case and palpable bias in favor. This overwrought legal language, these overwrought lawyers it just annoys me in any document you ever see it. Yeah, because it literally does, I think, devalue your argument.
Palpable bias.
I think it devalues your argument.
There was palpable bias. You could just feel it coming off of her, Judge. She was palpably biased.
She took it. If you don't know, just give her a palp test. There's a palp smear out there somewhere. You can check, see how palpable she was.
All right, this is devolved already. I knew this is where it was going, and this is where I always wanted it to go. Keep it up, Jeff.
I think if you're going to make an argument, keep it focused, keep it straight, keep it above board, and don't go overwrought with all of this. I mean, you can say the evidence reveals a level of involvement and bias in favor of the plaintiffs that was unacceptable. I think that's a much stronger argument than saying shocking levels of involvement in the case and palpable bias in favor of plaintiffs.
Palpable.
I read shocking and palpable, and I'm like, yeah, but is it really? Is it really shocking?
Is it really, though?
It's shocking he lived with his wife.
Oh, God.
As well as social media posts sharing inside information Ms. L could have only obtained from her husband.
Or could she have obtained it from us?
Yeah, well, let's as we go through this, keep in your mind every time they say, "Oh, she knew this, he knew that, he knew that." Did you also know that? If so, why were you talking to juror number 1? Because that's clearly the only way you could get information, according to them.
You've got to pull up Elsie Merritt's comment. Shapiro, you could smell the palpable coming off juror number 1. Anderson, I'm sure that was Dr. Jafar's Drakkar.
Oh, Drakkar. There's a flashback. Drakkar Noir. In the black bottle. Manders just gifted 5 Legal Vices memberships. Thank you so much, Manders. If you're one of the lucky 5 that got a membership from Manders, please give Manders a super special thanks. Can we not have anything else be palpable for the rest of the day, please?
If he uses the word palpable again, I'm taking a shot. That's happening.
Oh, yeah, I'm not doing any of that.
Right now, I'm just sipping, but I will down this.
Lime water for me.
Well, you had a rough night.
No, I had a very good night. It's a rough morning. So considering its totality, yes. The evidence provides a reasonable basis for a belief that juror number 1 disregarded his juror oath and this court's instructions by engaging in improper jury communications and contacts.
Well, that sounds really bad, but now prove it.
Well, do we even have to prove it? Because the very next sentence, juror number 1's own post-verdict involvement on social media.
That proves nothing.
He can do whatever the flippin' flying F he wants after jury duty.
Yes, which is why I did not understand the heart attacks about, oh, he shouldn't talk to the press. Yes, he should. If he wants to talk to the press, he should talk to the press. There's absolutely no reason he can't. The judge literally gave him the direction. You are free to talk to whoever you want. After the verdict, he can do whatever he wants. He can get up and he can enjoy his 15 minutes of fame. Yeah. He can write a book. He can go on Oprah. He can do whatever he wants.
John Gordon said, I bet the two even sleep together. Shame, shame, shame. Yeah. That's the new scandalous book. I slept with juror number 1.
I heard that Mrs. L has pinched the ass of
Oh,
juror
dear.
number 1.
And she's worried about me devolving this thing. Okay. So, juror number 1's own post-verdict involvement on social media corroborates defendant's belief that the L's engaged in improper contacts and communications during the case and formed a shared bias in plaintiff's favor, as evidenced by the verdict. So, juror number 1's wife's engagement in social media, it was biased for the plaintiffs, and that affected the verdict. That's what they're saying.
Can I just tell you that my husband is not interested in anything that I do on social media? He doesn't follow my Twitter account. He's not even on Twitter. He has no idea what I'm watching or reading. And when I try to tell him about it, he looks at me like he just tried to tell me how to fix an engine. That's what happens. And he completely, to this day, if I say, the Maya Kowalski case, he goes, who? And I've told him about this case about 20 times. You know what he compared it to? Yeah. You're going to laugh, Jeff. He goes, this case is your K-pop and I'm tired of it. My daughter is totally obsessed with K-pop. He goes, this is your K-pop. Yeah.
That's good. I like it.
And husbands and wives they're not often interested in the same shit.
And some people take their juror oath seriously, and they go, oh my gosh, sorry, can't talk about this, or let's please, for the love of God, talk about anything else other than what I've been doing for the last 8 to 10 hours of today.
Not to mention that he's a former law enforcement officer.
Yeah. Oh, we get into that part of it too.
He can't talk to her about his job either, and he spent however long they've been married not talking to her about work when he comes home.
Right. It just gets worse. Where are we at here? In addition to the presumptively prejudicial contacts and communication between juror number 1 and his wife, the evidence warrants a juror interview and a new trial for the added reason that juror number 1's wife's involvement on social media during the course of the trial, her undisguised bias in favor of plaintiffs, and her alignment with a social media influencer closely linked to plaintiffs known as Jules, as the spouse of the jury foreman, undeniably compromises the integrity of the juries. How the flying F does his wife, who has no oath whatsoever, she's not under oath, she's not under any restriction. How does
she is? They're acting like she is.
And it doesn't matter if she's the spouse of the jury underline foreman or juror number whatever, random juror. His position as a foreman does not give him any more or less power authority than anyone else. He's just the guy that has to sign off on the paper and read it occasionally. This is the most freaking ridiculous thing ever. This is just dumb.
It is dumb.
His wife's involvement on social media during the trial.
Elsie Merritt says, so this is jury misconduct by proxy.
Oh, no.
Yeah. This is she's got Munchausen syndrome by proxy for the juror does. He's got juror misconduct by proxy. This is genius, Elsie Merritt. Genius. This is the debate they should have made.
Jules does not want this fame.
Hi, Jules.
I'm
sure you don't. I'm very sorry. I'm very sorry they did this to you. And you know what? It'll pass.
This motion has brought a lot of unwanted fame to a lot of people. Mm-hmm. Shame on the defense.
The defense had no business writing this, and especially talking about Jules the way they did. Jules had a right to be in the courtroom. She had a right to talk to whoever she wanted. And this is just silly. They're grasping at straws, and it's silly. I'm sorry, Jules.
Yeah.
Oh, also,
this
Jules,
whole thing is unsavory.
You also have a right to be an advocate for whatever you want. Okay, you have a right to be an advocate to whoever for whatever cause you want. This idea, it also, to me, Jeff, smacks of intimidation of advocates, intimidation of people who want to support victims of medical malpractice. They'll think again, right? After watching what happened to Jules here, they'll think again before going out and protesting and going to court and being there to support someone, because they could be splashed across newspapers like the second, coming of Satan himself. Like the hell.
There's a big difference between somebody sitting in a court, someone watching a trial, someone posting on social media, and somebody filling the entire courtroom with people wearing bright yellow, neon yellow shirts saying "Bomb J Hatch." There's a big difference between those.
Yeah.
Yeah,
And that would not be allowed anyway. The judge wouldn't allow that in a courtroom. And, Jules was never, let's point this out. Jules was never admonished in court for anything. The judge
there's
never.
nothing to admonish for.
Well, right. But everyone should be aware. She was never admonished by the judge, or nothing ever was said to her that she was doing anything inappropriate. This is all just sour grapes by a desperate defense that is just throwing everything at the wall they possibly can to overturn this.
And we do have to give a super special thanks and shout out to Torin3 and Steve Gosney, who have both just very recently rated us here. Welcome, guys. Well, welcome from the other channels. We're getting into it now. So apparently, this is the most this is one of the most ridiculous parts of a sentence I have read probably in my entire life. Ugh.
Oh boy, here we go.
No,
the one we just read. Yeah, the one we just read.
Juror number 1's wife's involvement on social media during the course of her trial, her undisguised fire.
Jeff.
In favor of the plaintiffs.
If she disguised it?
Yeah. Then would have been her hidden bias. And her alignment with social media influencer closely linked to plaintiffs known as Jules, and the spouse of the jury foreman undeniably compromises the integrity of the judicial system. That is just stupid. That is just ridiculous and dumb. The juror's wife is under no obligation or restriction whatsoever. Defendant therefore moves for an order permitting an interview of juror number 1 and his wife to establish the presumptively prejudicial contact. They just want to say, what do you guys talk about in the bedroom at night? And communications described herein as grounds for defendant's entitlement to a new trial. Defendant additionally moves for an order permitting discovery of information establishing juror misconduct by juror number 1, as well as an order requiring juror number 1 and his wife to preserve evidence, including text messages, social media activity, and other electronic data pertinent to their communications and contacts with one another and with other third parties regarding the case.
Can I just
or an emergency? Yes.
Who the hell, Jeff, would ever agree to sit on a jury again if this is allowed? If this right here is allowed, that you now, because you gave up all your time and energy and fortune, because you're not making any money at work right now, you're sitting there for 12 weeks to do your duty as a citizen, and then the losing side can interrogate your wife, can take your phone, download your messages, search through it to make some kind of hay out of it. Who the hell would ever agree to be on a jury again if this is allowed?
Well, why even have a jury if you can just go, somebody talked to somebody else, so let's flip the verdict. No.
It is jury intimidation, Miku. Thank you. Yes, it is. It's future jury intimidation. Does the Dick defense really think that they are going to get a new jury that isn't going to see them in exactly the same way this one did? Because I would actually bet that if they got a new jury, they would get the exact same outcome. Just saying.
If not even less favorable. Factual background. We can burn through this pretty quick because this is just a long list of what. No, this is where they kind of lay it out. They give the fact and then they give the legal basis and then they apply the basis to the facts. Post-trial research and information. What was that again? Post-trial research and information obtained regarding Ms. L's social media history reveals that her personal engagement.
Post-trial. How much you want to bet though that they were investigating them during the trial?
Well, this is the Miss L trial here in the motion. Jesus. Ms. L's social media history reveals that her personal engagement with the public commentary of this trial is unlike that of a member of the public who shares a general interest in the case, and is particularly inappropriate given her role as the wife of a jury foreman. Again, just know that after every sentence, I'm either going to say prove it or what does that have to do with it? She is under no oath to not discuss this case. They don't put the jurors' wives and husbands and significant others under oath not to discuss the case with anyone. They tell the juror that don't talk about this with your husband, wife, spouse, significant other, whatever. They don't tell the spouse, wife, husband, significant whatever to not talk about it. They're under no oath, and she can have whatever interest she wants in it. She can do whatever the hell she wants and post whatever the hell she wants, as long as she doesn't hear it from her husband. And if she does, that's still not her fault. That's the husband's fault. So they're trying to put her on trial for most of this motion. So just to know, that's what I'm thinking pretty much after every sentence. Ms. L's social media post foreshadowed questions from juror number 1 to witnesses.
And this is garbage.
Shared information on the thought processes of the jury and highlighted her heavy personal bias in favor of the plaintiffs and emotional investment in a verdict in their favor.
Her
bias apparently.
And her emotional investment has nothing to do with anything.
Yep.
That shouldn't be in there at all. The only thing that would be valid would be, did she have inside knowledge of the questions? Okay, that would be valid. The other stuff, her emotional investment, all of her, irrelevant.
Yeah. It is. And literally, just think that out loud after every sentence.
Yeah.
So what? Prove it. And it has nothing to do with her. Those are the 3 responses you're going to have to most of these sentences in this 40-page document. Okay, bias apparently shared by her husband, juror number 1. The post gives rise to a reasonable belief and concern on the part of the defendant that the jury's verdict has been tainted, and the defendant has been deprived of his right to a fair trial before an impartial jury. In addition to her post, Ms. L's presence at trial casts further doubt on the integrity of the jury verdict. She can go to whatever fetching courtroom she wants to go to.
It's a public trial. And yes, even if you're a juror, your whole family can show up at the court and watch the trial. The thing they're not allowed to do is talk to you about it. That's it. And there's no way she can be there, and she can talk to Jules too. Guess what?
Yeah.
She's not breaking any laws or oaths, because she's not under any, to talk to people in the courtroom. Nonsense. And frankly, who could blame this woman? This is a huge trial. It's a big deal. This is going down in history. It is a landmark case. And if she's a true crime fan, as she obviously is, and follows all of us and all of, court TV and law and crime, of course she's going to be watching this. But
yeah, well, we're going to be asking a lot of these stupid rhetorical questions as we go along, because this is, as you kids say, it's redonkulous. You kids still say that.
That's
hello,
a voice
fellow
you don't
youths.
use often enough. That's funny.
In addition to her
Fellow
post,
youths.
Ms. L's presence at trial casts further doubt on the integrity of the jury. It does not, which was guided by her husband.
What does that even mean?
A jury foreman does not guide a verdict. He's one of 6 people in a room. They go, he's the one that's like, all right, vote. Ooh, that's guiding it. All right, I guess I got to sign the paper. I'm the jury foreman. They don't guide it. They don't direct people. This is the
argument that they're making in the 100-page motion they filed today. That is also the argument that they're making, that juror number 1 orchestrated this entire verdict. And it is so outrageous and stupid. It's like the other 5 people had no autonomy at all and no opinions of their own. And it was just juror number 1 going, if you don't vote the way I want you to, I'll have you stalked by police officers for the rest of your life. It's just crazy. But it's stupid.
Yeah. There's a lot of that going around. On October 30th, 2023, Ms. L physically attended the trial proceedings in this case, where her husband was impaneled as juror number 1. Juror number 1 said nothing of her presence. What's he supposed to go? Hey, there's my wife. Hi, Mom. He didn't. He hid his wife. Who the F cares?
She wasn't hiding. She was sitting right there.
Now, see, after Dr. Corcoran followed me on Twitter, now I feel the urge to bring my F-bombs in check. Daddy's watching.
The F-bombs. I don't think it was the F-bombs, Jeff.
Anyway, moving right along. Ms. L sought out Jules.
Moving right along.
Yeah. Jules has been sought after, who was demonstrably embedded with the plaintiffs and served as their public advocate, if not de facto agent. No, that's actually a legal term, guys. But at trial and subsequent to the verdict, both at trial and subsequent to the verdict, after the verdict, Ms. L and Jules exchanged personal phone numbers. Ooh, and Ms. L, where's the juror number 1 misconduct?
This is all about the wifey.
Yeah.
It's all about wifey misconduct.
Yeah, who can do whatever the F she pleases. It's Steve Gosney says, this motion assumes the husband listens to his wife.
Jeff, I have my troll is back in your audience. Steak is great is back. He wants to know why you have this bitch on. And now I have to ask you.
Because this bitch is funny.
I have to ask you to come
Yes.
come clean now to the chat about who you had to ask to locate this document.
Yeah. This bitch is smarter than me too, and she's only medium smart. So what does that tell you about me?
No, my favorite thing you said to me this week was, imagine how smart you would be if you were a man. Jeff was having a little bit of a problem locating this document.
Well, because the 12th Circuit, the Sarasota court webpage is the worst I've ever seen. Looks like it was done using.
You were on the wrong website.
Yeah, I was on the wrong website. I wasn't on the 12th District Court when it said 12th District Court, Sarasota, Florida, right there, with all of its flash. It looks like it was designed by a 3rd grader in 1997.
So he
That's
asked
how
me for
bad that
help,
is.
and I said, okay, I'll give you help, but you have to tell me I'm just as smart as a lawyer.
Smarter than him, apparently. Makes you de facto
Seriously,
smart.
though, I'm going to get that on a bumper sticker. That imagine how smart I'd be if I were a man.
All right, let's get back into this. So they exchanged personal phone numbers.
Oh no!
And Ms. L made plans days in advance to meet Jules in the courtroom.
Oh no!
On October 30th, I'm getting the vapors. October 30th, 2023, Ms. L can be seen in video footage in the courtroom for the entire day, often italics, seated next to and speaking with Jules. Not the italics.
He uses italics in the most hilarious way.
Not the italics. No. She was in court.
Speaking with Jules.
She was in court talking to someone?
How dare you?
Oh, God, I'm crying.
This is so dumb.
I'm crying.
This is so dumb. For her part, Jules, who I don't think was a sworn juror either under any obligation, became notorious in the online communities that covered the trial because she not only physically attended each day of trial, but also provided regular updates on her social media platform, almost like a news channel does. Those people from Law and Crime, they were in court physically every day, and they provided updates regularly on their social media platforms such as TikTok and YouTube. Why isn't Law and Crime mentioned here?
Oh God.
Jules also shared her personal conversations with the Kowalski family. I don't think they're under an oath not to talk about the case with anyone either.
They're not.
As well as observations in the courtroom regarding the jury. Almost like every other person on earth. It's apparent from these videos that Jules shares a close relationship with Jack and Maya Kowalski. So I'm getting closer to F-bombs. So effing what? Making her friendship with Ms. L all the more inappropriate.
Wait, I'm sorry.
Jules
has an acquaintance with the Kowalskis that she literally met in court for the first time.
Yes.
And somehow that makes her also talking to a juror's wife more inappropriate.
How dare you?
So crazy. Kitty wants to know, is Shapiro on his period? That's possible.
Shapiro, I believe that's his name. Shapiro.
He could have written this in a hormonal frenzy, with lacking some dark chocolate and good wine, perhaps.
All right, we've got some super chats here to read before we get too far behind. Indulge me, people.
Okay.
I don't want to get too far behind on these because I always feel guilty. Heather Sparrow, member for 10 months. Mr. Shapiro needs his smelling salts. J Hatch Reddit, am I the asshole? Thank you, Jennifer. Yes, you are the asshole, J Hatch. And what I'm going to do is, I can't give the bell to 12 of these. Everyone will get it. I'm just going to give everyone the big foghorn as a collective. Thank you, super chatters, for everything. Thank you for your support. Filing is dripping with misogyny. Hunter, you mad, bro?
It is, though. It is. It's like
It is.
this woman could not possibly have her own thoughts or opinions on things without being told what to think by her husband.
Yes.
What?
Unfortunately, he's failed in he's failed in perfecting the misogyny. He hasn't mentioned hysteria once, nor the vapors.
That might be still coming, though. Stay tuned.
Yeah. Not even Murdoch's defense team is stooping this low, and that says a lot. Dana loves Zoom, but yeah, they're just saying actual people involved in the courtroom process are doing things wrong. They're not blaming the jurors. And you saw how well it went when Elaine tried to blame the jurors in the Johnny Depp trial. You saw how well that went over. She shut the F up about that one pretty quickly. Christine Fortunato has been a member for 1 month. Thank you so much, Christine. And thank you, Dana Loves Zumba. And thank you, T-Rex Trucking. It's been a minute, bro. Been good. Haven't seen you since Houston. Hello, Legal Vices and Medium Smart Megan Fox, the investigative journalist. Art. Imagine if she was a man. Rosalind Duke gifted 5 Legal Vices memberships. Rosalind Duke, thank you so very, very much for the 5 gifted memberships. I hope you all gave her a super, super thank you. And Tara Rayner, Shapiro wife should preserve her communications. Yes, she was clearly biased against the plaintiffs. Shapiro's wife was, and she was in the courtroom, and she sleeps with a lawyer in the case, for God's sake. That's inappropriate.
I guess in every court trial now, everyone has to stop having relations with everyone in their lives.
Exactly.
Totally. Can't speak or sleep with or anything with anyone.
And Jessica Logalbo, thank you so much for the $10. I lived with my husband for the last 9 weeks, watched coverage night and day, and he has zero knowledge of the case. He's been watching football and comedy specials.
And I tried to tell him. I even tried to tell mine, and he still blocked it out. So, oh no.
Uh-oh. Medium Smart's talking again.
Exactly. He's like, who? What? No.
Yeah.
The bills are
Ellie Fant, Jeff said taint. No, I said tainted. Jay Hatch is shit. YouTube is gay. Megan is awesome sauce. I love when you two stream together. I hope y'all had a great Thanksgiving. Oh, thank you so much. And Heather Sparrow also gifted 5 Legal Vices memberships. Thank you so much for that. And give her a super special thing.
Celibacy in the court, please.
Ellie Fant, member longer than 7 months. Jeff is awesome. Thank you so much. KBF with the $5 super chat. Thank you so much. Defense cut and paste this evidence from the r/take care of Maya free from the Reddit and didn't bother to vet any of it. Some has already been debunked. Well, yeah. Hey, this is just the spaghetti defense. You got to put everything up and see what sticks. Future jury question: do you follow LawTube? Oh, I'm sure
that it will be. It will
oh,
be.
Yeah.
That's true. Because this is becoming like a real thing, isn't it?
It is. And Tara Rayner with a $2 Canadian, so that's like 3 cents. Just kidding. Thank you. I was just being saucy. I hear that in Emily's voice every time, Elaine. Give it a whirl. Panda, new member. What's up, Panda? Oh, Randy Panda, whatever. Thanks, Panda. Welcome, new member. Deeply, deeply appreciated. Thank you so much. I wanted to clear those off because if I get too far behind, then people are like, oh, you're the super chats, and then I feel bad and I feel guilty. Now, with a clean conscience, we can move on to the next paragraph of absurdity. Okay.
The children are clearly trying to get in this room. Hold on. Be right back.
they're trying to get out of the closet, actually. Okay, let's talk about this inappropriate relationship, shall we, that has literally nothing to do with juror number 1's behavior. For example, on October 9th, 2023, Jules posted a video on her TikTok page stating that she gave Maya Kowalski her rosary beads prior to Maya's live testimony that day. SFW. So effing what? On October 11th, Jules called out a recovery addict YouTube live stream, called into the recovery addict YouTube live stream. Yet again, another person who has zero F's to do with this case, stating that she texted with Maya over the weekend, and after giving her the rosary beads, asked plaintiff's counsel to not object to the jury's questioning regarding whether Maya carried a rosary because she knew Maya had the rosary bead in her pocket. So, this demonstrates that Jules was more than just a public observer of the trial. So,
No, actually, no. But when you get to the actual, I think it's in his affidavit, or maybe it's later in this thing. But he says that Jules actually told a clerk, the redheaded clerk, this. So he lied here. He said that she told plaintiff's counsel not to object. But later, maybe the affidavit that I attached, I think I was reading that yesterday, he said she told the redheaded clerk. Jules is saying that's true. So she didn't actually talk to plaintiff's counsel. She talked to a clerk. So
that raises a very good question, Megan. Let's say she talked directly to the lawyer. Let's say she talked to the clerk. So what?
So what?
So what?
So what?
Now,
Absolutely. So what?
If she ran up to juror number one and put the sharp end of the rosary to throw it and says, then we'd have a conversation. You put the pointy end at
Jules is saying, no, I did not talk to the lawyer.
Yeah.
And he knows she didn't talk to the lawyer because in another filing in his affidavit, he explains that she talked to the redheaded clerk. Well, the redheaded clerk is not plaintiff's counsel. So who wrote this? That she asked plaintiff's counsel to not object to the jury's questions. No, she didn't. And you know that.
Yes.
He knows that. So this is a lie.
So talk to the redheaded step clerk.
Allie is using my sister's favorite phrase, Jimmy crack corn and that's what she does. You have to fill in the blank.
Yes.
Jimmy crack corn and
I don't give a flying
exactly
basket of F's. Again, this demonstrates that Jules was more than just a public observer. But an active participant and de facto agent for the plaintiffs. Jules even publicly shared photographs of herself with plaintiffs' experts.
So?
And don't forget, Ben Chu uploaded photos of llamas.
Right. We read about that in the sidebars.
Yes.
Llamas. Jessica says ChatGPT wrote this.
Yeah. No, Chat GPT wouldn't even write something like this.
That's an insult to ChatGPT.
She publicly shared photographs of herself with plaintiff's expert and members of the plaintiff's team, but there were no llamas, so it's safe. And even appeared center stage.
Why is this about Jules?
What
does Jules have to do with juror number one? What is this?
None of this has anything to do with juror number one so far, and we're 1/4 of the way through it, which means we're going to be here for 4 hours. By the way, if you're doing that,
I'm sorry.
No,
continue.
No, it's us.
This is just what we do, Jeff.
And even appeared center stage in a photograph of the plaintiffs and their counsel after the verdict was read.
So what?
What are you going to say? Hey, can I take a picture with you guys? And I'm just going to stand like way over here.
And they're going to say no.
But I don't want to be seen as center stage, so I'm just going to go stand over here by this bush. So just take a really wide shot. Our words are about to drop. In light of Jules' intimate relationship with and bias in favor of the plaintiffs, the development of an alignment, if not friendship, between Jules and juror number one. I'm sorry. Juror number one's wife is alarming.
Can I just say, if that is proof of an intimate relationship, then I had an intimate relationship with Sam Donaldson. Because I was pictured.
I can't see that. I was doing an eyebrow raise, but you can't see it under the hat.
I saw the spit take though. I was doing an eye raise. I was center stage in a picture with Sam Donaldson in 2004, and that picture is on my Facebook page, which means that me and Sam Donaldson had an intimate relationship, doesn't it?
Kinda, yeah.
According to Ethan Shapiro. The chat's like, ew.
Yeah. Well,
But
see,
I mean, this is their
I don't
only
want to
evidence
put
that there's
words
an
into Jules'
intimate
mouth, particularly
relationship.
seeing as how she's here in chat, but I can just imagine, just be like, what the actual F is going on here? I mean, this is just idiotic. Ugh. The,
Well,
if
it's
not the
a picture with
development of it.
someone. A picture with someone certainly does not connotate an intimate relationship by any means. That
Yeah.
is not evidence of an intimate relationship. And anyway, why would it matter?
Well, we're going to get into juror number one's conduct, obviously, how he violated the jury's right to a fair, the hospital's right to a fair jury trial. We're going to get into that right now with this next sentence. Defendant was entitled to a trial before a fair and impartial jury. The fact that the jury foreman's wife, oh, wait a minute, no, we're not. Back to the jury, back to juror's wife's conduct.
We're back to wifey's
Yes,
conduct.
with whom he was residing during the course of the 9-week
Again,
trial.
with the residing. We know that husbands and wives live together. Oh my God. Unless, by the way, shall we say, unless J Hatch has driven them apart due to taking their child and trying to drive a wedge between a husband and a wife. In that case, then they would be living apart. So there's that.
And they engaged in friendly discussions while in close proximity to the plaintiff's advocate, Jules.
Oh, no.
This contributes to the defendant's reasonable belief that has been denied its right to a fair trial. So, some dude that's friends with the plaintiff, some girl, some lady, some gal, some chica who's friends, who has been in there long enough that people go, hey, who are you and what are you doing here? Becomes friends with this person and friends with that person. Somehow it affects the right to a fair trial because people are actually getting along and making friends. Shocking. Defendant has obtained evidence demonstrating that Mrs. L was heavily engaged with the trial online both before and after she physically appeared in court. Me sound like some sort of ghost. She just physically appeared in court. I saw right over there, right next to that shadow of Jesus on the wall. She appeared. She appeared physically in court. She manifested. She manifested right there in court.
Was it Dumpster Jesus?
Right next to where Dumpster Jesus used to be. The Virgin Mary couldn't appear because she's out looking for Jesus in the dumpster. So, you know.
J Hatch banned the Virgin Mary and threw Dumpster Jesus out.
She physically appeared in court, just manifest.
Physically appeared.
Posting comments.
Oh no, I have to take a shot. Look what's coming. Oh shit. Here we go. I said I would do it.
I think you have to take two because it's in italics.
I never made
before.
that roll. I never made that roll. I'll wait till you read it and then it's going down.
So, appeared in court, posting comments. This is Mrs. L here. Posting comments about the case that are in italics, unequivocally and palpably pro plaintiff.
Cheers.
Cheers. Megan is taking a shot for every time he uses the word palpably in this. She has no idea what she's getting into. Operating under the YouTube name Hippo Lover. Ms. L began posting information, insights, and opinions about the case as early as October 13th, 2023. During live stream coverage of the trial on the Law and Lumber, Recovery Addict, and Lawyer YouTube channels, and followed numerous journalists.
That's me. That's me who he's talking about. I'm the journalist.
Yes, and there's photographic proof in the exhibits. Megan is in an exhibit. Megan's an exhibit.
I am finally not the blogger and the vlogger. I'm the journalist.
Yes.
I've made
She physically appears in the exhibits.
Dun dun dun.
Yes, literally, they're saying the juror number one's wife reads news.
How dare she?
She reads news about the single most important case that's happening in her neighborhood now. And followed numerous journalists and vloggers. MySpace wants your term vlogger back.
I do object, though, that my Twitter account was right beneath that twat waffles at Court TV. I object that she followed Court TV before following me. I object. Those people are twat waffles. Stop following them. Just saying.
But I really like they let me use their feed. But other than that, yeah.
Yeah, I like that
And
part, but not the cunty activities of their cameramen. I'm sorry, was I not allowed to say that yet? I've
no,
had a shot, Jeff.
I was gonna say, see, Dr. Goodhair, I'm the good one in this relationship. There's a story there, but anyway. So
Jeff has
she,
Jeff told an
yeah, let's just move on.
unwieldy joke.
And followed numerous journalists and vloggers covering this trial, including the producer of the Netflix documentary "Take Care of Maya."
What's
And
a vlogger? Who's the
that
vlogger?
that's what you used to call streamers or video loggers back in the
He's
MySpace days.
seriously calling us vloggers? Because no,
Yes.
that's
Well,
not
that's
what
the
we are. We're not
yeah,
Ruby. What's her name?
nobody has been a vlogger since MySpace.
Yeah, no, we're streamers. We're streamers. Get the right wording in here. It's not 1999.
But we're gonna party like it is with all the palpability going on here.
If that word is in here again, I'm in trouble.
You are.
Yeah,
The
Ruby
plaintiff's
Frankie,
trial
thank
technology. Oh, sweet Jesus, Mrs. L was in contact with the plaintiff's trial technology consultant.
Oh,
Turn up the fucking microphone. Oh, I dropped one. Turn up the microphone. Oh, my Lord.
Who's the technology consultant? I heard
Megan,
I heard
let's
Judge Carroll was
isolate
the
this.
technology consultant.
Let's isolate this. This jury, this whole verdict needs to be thrown out because this jury was tainted and the hospital was denied a fair trial because one of the jurors' wives made friends with the trial technology consultant.
This sounds so much more ridiculous when you read it. I mean, I thought it was ridiculous when I first read it, but it is now so much
That's
more.
what they're saying.
I know.
The juror's wife is friends with the plaintiff's trial technology consultant, so therefore, this needs a new trial.
Because maybe she asked him to, like, where could she plug in something, probably.
Good Lord.
And charger. With the amount of screens that Judge Carroll had, he had like 6 screens in front of him. He doesn't need a technology expert. He is the technology expert in the room. Although someone needs to teach him how to turn the lights down.
And get a haircut.
Although I'm starting to think, Jeff, that the tuft of justice may just be like a beacon that
like a third eye.
Like alerts him to bullshit and like stands up when there's bullshit around. Like maybe he just needs
Hair
it.
Island chakra is what it is.
He needs it.
Okay.
My headphones. Come back. I can't.
Wow, that's
okay. Sorry.
Okay. Well, anyway, so on a nearly daily basis, Mrs. L spent hours online engaged in commentary about the trial proceedings, both in real time and after the trial had ended and the jury was sent home. Parentheses, including her husband with whom she resided.
Again, with whom she resided. Are you?
They were definitely sleeping together. I know that.
Oh, for sure. I bet she gave him some extra.
No, don't finish that. Don't finish that sentence. The social media platforms.
She was so excited by his involvement in this trial. She was like, "I need to thank you." Like.
I'm the good guy in this relationship. These social media platforms transmitted commentary to audiences of thousands and exposed Mrs. L and brought into the L household information about the trial that juror number 1 should not have been aware of. Prove he was effing aware of it. Prove he was aware of it. What is one single shred or iota of evidence that he was aware of this?
I guarantee you that this poor man came home from trial every day, got himself a Sammy or whatever it was Mrs. L made for dinner, and passed out in front of the television every night. There was none of this. Do you think what do men want to do when they come home? They sure as shit do not want to talk about all the shit they just
They
went
sure
through.
shit don't want to talk to their wives.
No, they don't. Somebody in the chat earlier said he used this trial as an excuse not to talk to her for 12 weeks. Absolutely.
Yeah.
Look, and you know what? We're fine with it. I've been married 23 years. We don't talk very often because we don't have anything to talk about. When we have something to talk about, we talk.
Yeah.
We don't. And guess what? We live very nicely together. Like it's fine. Nobody needs to be like up in your business all the time. Like, what are you doing? What are you doing? No, that's not how it is. Bullshit.
Yeah.
You leave him alone. He comes home from work. He's tired. He wants to eat. He wants to sleep. He wants to watch a ball game. Leave him alone.
Exactly. All right, let's continue this mess. This is just icky. And by the way, we have over 1,000 viewers here right now. Thank you, all you guys. Please do me a favor while we're reading this. And you've been here more than 20 seconds, so clearly at least something is likable about this. Drop down there and hit that like button, please. I would love to. And if you're not a subscriber to the channel, this is what we do. We do trials. We do legal things. We're doing this. We've got a major maritime disaster from a few hundred years ago on Monday. YNW Melly trial news coming up on Tuesday. Wednesday, probably talking some Murdoch developments. And we're this is what we do, and we have fun while we're doing it. We don't take ourselves as seriously as other people do. But we're well, I would say we're smart, but one of us is medium smart. If she were a man, she'd be smart.
If I were a man,
yeah, exactly.
I would be unstoppable, frankly.
So yeah, I would appreciate the likes and the subscribers. If any of you feel like the urge to subscribe, I would be gratefully indebted.
The urge to subscribe is palpable. You're feeling it right now. Your thumbs cannot resist the urge.
Don't make me physically appear. All right. Godfrey.
It's undeniable and palpable. Undeniable and palpable.
Okay, Shapiro, let's go. These social media platforms transmitted commentary to audiences of thousands. We read all this. The juror should not have been aware of, which we said prove that he was.
Did he say thousands?
Thousands.
I think that I'm actually very upset by that. Tens of thousands, hundreds of thousands.
There's still thousands.
There's not just thousands. It's probably millions. When you add it all up, the lawyer Law and Lumber, all of law to everybody's audiences, you're probably talking about millions, not thousands. At least hundreds of thousands.
It's just the same 10 of us that keep watching all the channels.
It's not the same 10.
I know.
I just feel like I'm offended by this number.
Are you palpably
I'm palpably offended.
We are now officially off the rails. Let's get back on here. So not only was it transmitting information that juror number one shouldn't have been aware of.
Trillions of us.
Trillions, I tell you. As well as evidence not made available to the jury. So the social media platforms are transmitting information that's not available to the jury. In several instances, Mrs. L even donated money to these YouTube channels that offered both live coverage and reaction commentary to the trial. Italics again, ensure that her comments would be spotlighted to the thousands of individuals that tuned into the live stream broadcast.
Mr. Shapiro, this is how the internet works. Welcome to the internet.
Yeah. I mean, again, the next sentence I highlighted because it's extra stupid. It strains credulity to believe that the L's were not discussing the case in violation of the court's instructions. That is just a flat out, bald-faced fucking assumption. The jurors living with the husband. It strains credulity to believe that there one piece of evidence.
Cats and dogs living together. Husbands and wives living together.
I mean, it's just saying there is no way you can reasonably expect me to believe that they weren't talking about the case. That's what they're saying. With zero evidence to prove any of that.
If that's the case, that it strains credulity to believe that husbands and wives don't talk to each other about cases that one is on, then why do we have the jury system that we have that allows a husband or a wife to go sit in court and then go home? If they really believe this, why not separate them then?
You presume the jurors are keeping their oaths until you have clear evidence that they are not. This is just a fishing expedition. They're living together, so therefore clear. You just strains credulity to believe they didn't talk about it. So let's bring them in here and interrogate them.
Well, if they're smart, we'll just say no. I don't think they're even going to be interrogated. I do not believe that the judge is going to allow this questioning because this motion is absurd.
It is. It's ridiculous.
Absurd. There's nothing in it that she couldn't have found out from all of us. We were
to the contrary, though,
the same thing.
To the contrary, the evidence provides more than a reasonable basis to believe that the L's were exchanging information and beliefs regarding the case and about defendant's predetermined culpability in violation of this court's instruction in Florida law. For example, during the live testimony of Detective Graham, at a time when the detective was under cross-examination by plaintiff's counsel, Mrs. L foreshadowed information she could only have learned from her husband, number one. Is this the only place, talking to juror number one, is this the only place you could have learned this information when she posted the following comment? The juror, law enforcement officer, will be asking questions.
No, we all said that. We were all like, hey, there's a former law enforcement officer on the jury, and he's totally going to want to question this bitch.
You were talking to juror number one, obviously, too, because the only way...
I'm sleeping with juror number one also. I must have been living with him, cooking him dinner at night, because I knew that information.
That's literally what every single person that watched this trial said. Oh, there's a cop on the jury. He's going to ask the cop some really tough questions.
Now, I admit that the wife of this man would know him better than anyone, but she would be able to say, this guy's going to have some questions. That does not mean he said to her, I have some questions. It just means she knows him. I know my husband. I know what he would do in most situations. I could say, this dude's going to have some questions.
Exactly. The day prior, Ms. L portended a challenge.
Oh, shit.
It was a harbinger of a challenge. They have like there's some law clerk in the firm that their sole duty is to like man the thesaurus. Portended a challenge by her husband. Juror number one.
They're so, what's the word I'm looking for? Not elitist. It's close though, but like
retarded.
Smarmy. They're just so smarmy.
Well, there's more smarm coming, Megan. Let's get to it. The day prior, Ms. L portended a challenge by her husband, juror number one, to Detective Grant when she posted Detective Grant, Leo, juror, lol. What the fuck that means, I have no idea.
Yes, what's that? Pompous is the word I was looking for. Thank you.
I'm not sure.
Another good one.
But how does this pretend a challenge when she says Detective Grant, Leo, lol?
I don't even know what that means. What does that even mean? Detective Grant, LEO, juror. But okay, so maybe she's saying Detective Grant, meet LEO, juror. But she didn't say that, so we don't really know what that means.
That's what it's... Anyway.
We don't even know what that means. I don't know.
On November 8th, 2023, while the jury was deliberating behind closed doors, Ms. Lengel paid to super chat the following comment. I think the note yesterday was frustrated jury that cannot reach a dollar agreement and it will take days. Ms. L apparently interpreting the juror's thoughts in relation to juror one's question the day prior regarding a request for a report by plaintiff's economist expert, Christy Kirby. And she was right. Her comment contained inside information she could only have obtained from her husband, juror number one.
The note was read in open court.
But before it was read, she said,
no. She said, I think.
Okay,
Yesterday.
Yes, you're.
It was read in court, Jeff.
Yeah. But the point is, they read that. They were there for what, an hour and a half or something, and they came out with, can we talk to the financial person? Every single person on LawTube, YouTube, True Crime, every single person said, oh yeah, they just want to know how many zeros.
How many zeros? We all said the same thing. But I mean, the note was read in open court.
Yeah.
So she's commenting on the note that was read that everybody else commented on. This is not inside information. It's her saying, I think they just can't come to an agreement. We were all saying the same thing. Yeah, they want to know how many zeros. Exactly how many?
Everybody said that. It's like it's a really bad thing when you're 9 weeks saying this shit never happened. You're in the jury room for 20 minutes and they come back and go, can you show us where to find all this shit on the drive about all of the money that they're going to have to pay?
Yeah.
That's a bad sign. We all know what that means. Ugh. On October 3rd, happy Halloween 2023, the day after the testimony of Catherine Beatty, Ms. L commented, the jury did not take Beatty or any of the the jury did not like Kathy Beatty. Well, there's a fucking revelation if ever there was one. Nobody could have known that nobody liked it.
Nobody liked her. Nobody liked any of those witches. The seventh floor coven. Nobody likes any of those bitches. Like
you can only have learned from juror number 1 that nobody liked Beatty. That's the only way you could know that.
Yeah, it's not
only through juror number 1.
Questions.
Yeah.
From her own experience watching Kathy Beatty on the stand. Nobody likes her. Maybe she was talking about, and wait, it says they did not like Kathy Beatty.
Yeah.
It
or any of the witnesses presented that day.
First of all, do you see what's in brackets? Look what's in brackets versus what's in quotes. What is in brackets is written by the defense.
Yeah.
What is in quotes was written by the juror's wife. So let's read what she actually said. They did not like her or any of the witnesses defendant presented at trial. Who's they? We don't know who she's talking about. Who is they? She could have been talking about the audiences. She could have been talking about, but it doesn't. Even if she is talking about the jury, it doesn't matter. But the point is, look how they added stuff. Look how they added this.
But how could Ms. L have known whether the jury liked Ms. Beatty from the information she obtained, aside from information she watched Beatty on the stand? There's a good clue that nobody liked her.
Nobody liked her because she's a repulsive figure in this, because we all know she has a criminal record for abusing a child, because she is disgusting and she was a bad witness. I don't know. None of us liked her. So,
but yeah, we couldn't know that unless we talked to juror number 1.
I guess not. I guess I just guessed all that.
And how could she have known that the jury did not like any of the other witnesses except for information? Other comments and posts by Ms. L reflect that she was doing more than inappropriately engaging with the trial proceedings online. She was even monitoring the court docket and reviewing court filings.
I was monitoring the court docket.
Improper journalist.
Jeff was trying to monitor the court docket, but he couldn't find it.
Yes. So I talked to Megan. And then Megan's a journalist, and juror number 1, she saw Megan's thing, and then she knew the plaintiff's trial tech guy, and then she looked at her husband. So therefore, we need a new trial because of you, Megan. Because of you and your docket knowledge. Jesus fucking hell.
She had the nerve to monitor the public docket that's publicly available to every person on earth.
And reviewing the court filings. For example, on October 18th, 2023, Ms. L commented, interesting motion just on the case about DV yesterday on the Sarasota County of Clerk of Court. If that site really exists. The DV motion by the defendants basically said that if the judge granted no appellate court. So what? Anyway, on November 3rd, regarding the Joint Commission issue that surfaced towards the end of the trial, Ms. L wrote, deposition today at 4 in Tampa regarding JC documents. Motion is in the record. Motion in the court record. By Mr. Anderson. Yeah. In that vein, Ms. L also did a Google research on the case. She Googled.
Google? Oh,
yes.
Lock her up. She should be using DuckDuckGo.
There was a case on Google, Carol versus Carol, about the Judge Carol mom, about the judge when he was 16. You mean the one that Megan Fox also read?
The one that I read? And you mean the one that Recovery Addict also tipped me off to? That's how I found it. And then I got it and read it. So Recovery Addict was talking about it that I know of for sure. And then I read it out loud on my channel to anyone who wanted to listen. So she didn't even have to do that Google research. She could have just heard it on our shows.
It's so ridiculous. Seriously.
I know his Rottenborn voice is totally coming out in this. It's really funny. You keep sliding into Rottenborn. I'm loving it, by the way.
That's just my sinister, evil lawyer voice. You can apply it to whoever you want, except for Elaine. So that about when he's 16, Judge Alterborn.
Alton
Alterborn.
Burned. Mr. Burns. Mr. Alton Burns.
Alterbon.
It's not Altabon.
Judge Alterbon was the appeal.
Oh, it's
Was the
Did they spell his? Oh, she spelled his name wrong. Alterbon. That's funny.
Alterborn would be like a cool name. I am Alterborn. Was the appeals judge supper interesting? She had an interesting dinner. Stoner.
Oh God.
Ms. L found she didn't find super interesting. She clearly says supper interesting. Mrs. L found super interesting and post-worthy that defense counsel Chris Altenburn was involved years ago in an appeal involving the judge presiding over the trial, which demonstrates how deeply involved she became, not only in observing and commenting, but in researching about the trial, the lawyers, and even the judge.
Mrs. L seems like a really smart lady that I would get along with and I would like very much. She does good research. She finds interesting shit. Like, I don't know. Seems like a cool lady.
Well, again, I ask you, we are 11 pages into this 40-page thing, so this actually can take like 6 hours. But where is juror number 1?
We still haven't heard anything that he allegedly did.
Not a thing. Not a damn thing.
Mm-mm.
This is all about his wife. All about her. On October 27, 2023, Ms. L commented, I think Sally SM only relied on the Tampa General Hospital to decide, discounted all others. Ms. L was advocating for the plaintiff's position and against the veracity of Dr. Sally Smith on a consequential issue in the case. So effing what? Not coincidentally, in a proposed question dated October 12th, 2023, Juror 1 questioned the court regarding the existence of probable cause of improper actions of Sally Smith in her assigned role at J Hatch, and she was written up or coached. Now look at this. See, they wanted us to look nefarious here. The question was on October 12th. Her comment was October 27th.
Oh, geez.
But they put the 27th one before the October 12th one to make it look like she said this, and then juror number 1 raised this question. And how do we even know it was juror number 1? They say, I'm juror number 6. This is my question. They didn't do that.
Well, but the lawyers knew. The lawyers knew which juror asked which question, and they kept track of juror number 1 because they were writing that motion to dismiss him. So they knew. But still,
this is some bullshit, though, to do it this way. On October 27th, Ms. L commented this, and then not coincidentally, this question, but they don't want you to go, but wait, coincidentally, 2 weeks before there was this question? And anyway, then
it didn't even make sense to me. I don't think it correlated. Look at the question.
Well, they both mentioned Sally Smith. That's pretty much it.
That's it. That's the only thing. Yeah. She's saying that she was written up or coached. His question says nothing of the kind.
Similarly, on October 19th, 2023, while the jury was formulating questions related to the testimony of Joanna Klink, APRN, Ms. L wrote, they should ask if she lied, lol. Ms. L's lol.
That has nothing to do with being coached, does it?
Nope.
I don't see how those two things are the same at all.
They don't. They're not. Ms. L's post as compared with juror number 1's questions are additional evidence of improper contacts. The question was anyway, it was before these comments. The question that they're saying was somehow similar to these were 1 week before one and 2 weeks before the other one. So,
stupid.
There are additional evidence of improper contacts and communication between the L's, warranting both a juror interview and a new trial under Florida law. Through several of her comments and posts, Ms. L also inappropriately expressed concern that the clock was running out for plaintiffs to put on their case. For example, in 4 separate comments posted on October 17th, Ms. L wrote, Anderson is burning time. He won't have any time left to defend. He needs to be careful on time. I think you're right. Depots to burn time. And bringing witnesses that will burn Anderson, so he'll use time. I wonder if the defense are getting the witnesses so Anderson runs out of time. Don't burn your hours, Anderson. Please, we need you, is what everyone said.
That's what we all said. We all said it. There was a literal clock every day after the trial. The judge would say how much time that the defense had left and how much time the plaintiff had left. And we were all saying, oh my God, Greg, speed it up. For God's sake, keep it short. Everybody was saying that. She didn't get that from her husband. She got it from watching the goddamn trial.
But why was Mrs. L of the opinion the plaintiffs were running out of time if she wasn't discussing the case with her
They
husband?
were. But they what? This,
Yes.
oh my
Yes.
God.
Why did she have this opinion? Like, I've never met her husband, and I wasn't even really covering the trial. And I'm like, why? Why are they running the clock like this?
We all
Yeah.
knew the clock was public knowledge. That's why. All of this stuff was public knowledge. They
Yeah.
have nothing, Jeff.
And
Nothing.
who was she referring to when she said, "I think you're right"? Her, who knows? That's your fucking thing to figure out. Her bias in favor of the plaintiffs and the depth of her knowledge regarding the case and her role as the jury foreperson's wife, doesn't matter, with whom she was living during the 9-week trial. There we go again.
Again.
It's undeniable.
Is that the
And
fifth time that they said
Megan?
she's living with him?
Megan.
Oh, fuck.
Make a
Not
pour.
palpable. Are you
Megan.
serious?
With whom she was living during the trial is undeniable and palpable.
Oh, no. This
And
is gonna
creates-
be bad.
I told you.
I'm going to have to get food.
It creates more than a reasonable basis. So the fact that she knew the clock was running out creates more than a reasonable basis to believe that what defendants suspected when they filed their motion to disqualify that juror number 1 shared the same bias. Ms. L also
use palpable in this thing.
Ms. L also somehow knew or believed that the jury was asking questions that were purportedly serving to save plaintiff's time on the shot clock. For example, on October 19th, 2023, Ms. L wrote, "Maybe Anderson will cross after questions to save time." On October 19th, Ms. L posted, "So proud of Anderson. He was like a cat. No questions after. Just to pounce after the jury questions." Kudos.
We all said the same thing. We liked that. He was like, just
Yeah.
sat down, let the jury ask the questions.
But-
That's fine.
But on October 20th, Ms. L paid to super chat the following comment.
Why are
If
we still
plaintiff
talking
runs out of
about
time,
wifey?
because they don't have anything to say about juror number 1. If plaintiff runs out of time, can the depositions be played since part of it goes to the plaintiff's time? And on October 25th, Ms. L commented, "Yes, more hours for plaintiff." In response to continued questions from jurors, Ms. L commented, "Jury, love it." Even if evidence of shared alignment between juror number 1 and his wife as to the desired outcome of the trial were not so compelling. So even if the previous 13 pages were bullshit, even if
everything that guy just says bullshit. Thank you.
even if that is the case, and it is, the defendant would still satisfy the standard for a juror interview. Specifically, the entire internet community
Italics.
of the heavy bias in plaintiff's favor on the part of a juror's wife.
The entire internet community.
I must admit, I was completely and utterly unaware of her
So
existence.
was I. I'm the internet community.
Defense made me aware of them through this motion. I had no idea she existed. The entire internet community was made aware of the heavy bias in plaintiff's favor on the part of the juror's wife, plainly compromising the integrity of the jury process. She's not on the fucking jury. I can't say that enough times, and I got to stop swearing. But this is as I said at the beginning, you range between rage and embarrassment for them, and then sometimes it's like you're laughing and raging at the same time. She's not on the jury.
No.
What she says on the internet has nothing to do with compromising the integrity of the jury process.
Here's a serious question, though. Serious question. I realized nothing she did was wrong. However, if you're on a jury or someone is going to be on a jury, do they now have to tell their spouse, you also have to act like you're on the jury?
No, they're not on the jury.
I know, but like,
They're
who
not.
wants to put up? But who wants to go through this? Who wants to
Nobody.
go through this? Nobody. Nobody wants to go. So now, if you're on a jury, you're probably going to turn to your spouse and be like, "You better not post about anything about this case at all. Just pretend like you don't know about it." Because
I mean, that is kind of wise
can
non-legal advice. Yeah.
I mean, right? But it is bullshit because it curtails
Let's do it.
somebody else's free speech
Yep.
who is not curtailed in any way by any court order, by any judge's order, by any
Yep.
oath, by anything.
Yep,
So it
exactly.
pisses me off on that level. But on another level, it's like, well, if you find yourself on one of these juries and it's a high profile, there's cameras in the courtroom. Here's how you know. If there's a camera in the courtroom, tell your spouse. Don't fucking post about this anywhere, because this shit will come back to bite us.
And you says when the entire internet community is biased against you, maybe you have a sucky case.
Yeah, you think? You think? All right,
as will be shown.
I'm going to pass
good.
out. I'll be right back.
Well, okay. I will read some super
Do
chats.
super chats.
All right. And we'll try to get through as much of this as we can because we love Megan. As will be shown, even an appearance of impropriety warrants a new trial as a matter of public policy under Florida law. Well, we'll see if it does. But let's look at a couple of the super chats here. We've hit the number that I'm comfortable with being in the background. Tammy F, new member. Oh, thank you so much, Tammy F. I'm so thankful that you became a new member of the channel. And Tara Rayner. Okay, we're going to do a big. Normally, what I do here on the channel is because I practice maritime law. I'm a maritime lawyer guy. I usually do ship's bells, but I'm not going to do that to you 10 times. So we'll just do the big foghorn collectively as a thank you to everyone who has chatted and joined and et cetera, et cetera. So thank you to all of you supporters. And thank you to all of you that are just chatting and having a good time here and chat with us. Can we all agree, though, that the mic picture was unfortunate and I didn't need my husband to give me permission for this opinion? The chat worth a loony. Yeah, that particular picture of the person standing with the awkwardly positioned mic was a bad look. That was literally the first. I mean, maybe it's just I'm a degenerate. The very first time I tuned into that trial, I went, "What on earth is that?" Ugh. Kimmy, member for 6 months. Does J Hatch really want to go down the road of a new trial? Oh yeah, because they don't want to pay $216 million, $250 million, or however the hell, man, $261 million or whatever the number was. They don't want to pay more than $200. Would IJ report, assault, etc. be allowed in a new trial? I'd loll if plaintiff awarded more. That is a that's a very real risk. But I thought some of the numbers were quite conservative. Tiny Tina, thank you so much for the £2. Shapiro makes Elaine look competent. Ooh, I don't know if I'd go that far, but because that's a pretty high standard to meet. But run for the money. They're in the discussion. And Tara, again, thank you so much. The judge should order Hunter use a thesaurus and learn a new word. By the way, what I plunged with this filing was palpable. Good thing Megan's not here. Knows this chat. Oh, smelly shit. Okay, this chat is worth a loony. We'll get the loony here. His former Leo. He is former Leo. He likely questions everyone. Well, see, that's the thing. He's a law enforcement officer. There's a law enforcement officer on the stand. That's why jurors asking questions, I think, are fascinating, because he would ask questions that that not even normal lawyers would answer. He would have some very specific questions for law enforcement officers that other people might not think of. So I think it's very interesting when they ask the questions. I'm starting to think the writer of this motion paid too much attention to Darrell Brooks. It's that bad. Grounds. Tara, again, Hunter and Shapiro wives usually ask how to think. Ooh. Burn. Thank you for that. And Tara, again, Judge Carol Gerber, baby, grown up, needs to lose JT. Oh, he does kind of look like Gerber, baby, doesn't he? That's cute. And Crystal Pontac, new member. Thank you so much, Crystal. And Moon Sausage, OSRS, defendant's motion. We also have it on good authority that Juror 1's wife did, with intention and non-malice, did cook him food, and he ate it. Totally. We all know. Oh, and one more just under the wire, so we'll get this out of the way, and then I'll jump back into the motion here while Megan does what any good woman should do. I wonder, says McRae, I wondered from the beginning how wise it is for jurors to ask questions so blatantly revealing what side they're leaning to. You can see, that's the thing, is you can have opinions. You just can't make up your mind before the jury deliberations begin. You can have opinions and thoughts, and I dare say even have bias, but you can't, that's a really good argument. They need to explain this away, but they can't come to a decision. I mean, bias is kind of a weird word. You can have opinions, you can have beliefs, you can have thoughts, you can have questions. You just can't say, all right, I'm done. I've heard enough. I don't need to hear anymore. This person's clearly guilty, or this person is clearly liable, or this person is clearly off the hook. You can't say that. You can't come to that conclusion before you get into the jury and start deliberation. But you're allowed to have thoughts. You're human. Ugh. People annoy me sometimes. And this is a really annoying motion. As his wife and household companion during the course of the 9-week trial, Ms. L was serving as jurors once agent to the internet world. That, we'll just say, is a bullshit statement. That's a bullshit statement. Was serving as his agent to the internet. She was not his mouthpiece. She was not speaking for juror number 1 by any stretch of any imagination that I've seen, even looking at the exhibits. Nothing says I am here acting and speaking for and on behalf of juror number 1. None of that. Ms. L has compromised the public's confidence in the integrity of the jury system through her biased posts and improper emotional investment in the verdict in plaintiff's favor, given her role as juror number 1's spouse. Look, take juror number 1's spouse off of this. Random internet person. We'll just call her random internet person right now. Random internet person has compromised the public confidence in the integrity of the jury system through her biased posts and improper emotion. Let's do this. Let's flip it on all of you in chat. Every one of you in chat, we'll use your name here. Person in chat, you have compromised the public confidence in the integrity of the jury system through your biased posts, your biased chats, your improper emotional investment in the verdict in plaintiff's favor. Does that sound as ridiculously stupid to you as it should? You in chat, you have compromised the public confidence in the integrity because you post stuff like this. And then you just add as juror number 1 spouse. That as juror number 1 spouse has no meaning whatsoever. She is under no restrictions as to what she can say, post, do, etc. She is just as free as you and me and everybody else. This is frustrating. They just say shit and then they throw as juror number 1 spouse at the end to make it sound somehow egregious, and it's not. Her actions also brought information from the L's household information into the L's household. This court prohibited the jurors from reviewing. Who said the juror reviewed it? Who said that? Where does it say the jurors were reviewing this? Nowhere. I don't see it anywhere. On November 6, 2023, the court heard defendant's motion to disqualify juror number 1, which was premised on juror number 1's suspected bias and prejudice in favor of plaintiffs. Plaintiff's counsel, Mr. Anderson, changed his position several times throughout the course of the oral argument on defendant's motion. Upon being pressed for a response by the court, Mr. Anderson replied, "I changed my mind. I'll go with juror number 106, so I'll agree with you." Okay, all right, we're making a big deal about one juror. All right, whatever. You want to replace the juror? We got backups. Fine, let's do it. I'm happy to go with juror number 106. That's a completely reasonable, rational thing to do. I got no problem with that. He's like, all right, whatever. We're making a big deal about it. Let's just, move on to someone else. I'll agree with you. We'll do it. The court then pressed again, and Mr. Anderson responded, I think I'm gonna go with that. So he's like, yeah, cool. Let's still go with 106. Fine. Then, as the court was outlining the agreement of the parties and identifying which alternate would take juror 1's place, Mr. Anderson abruptly announced, "You know what? I didn't check. You know who I didn't check with throughout this whole thing? My client." Okay, so this is what a lawyer should do. This is literally his responsibility. It's his client gets to make decisions. And this is one, and that's all he said. He said, okay, fine, we're arguing about this. We'll go with whoever you want. Let's see, let's draft the whatever instructions we need to do. Let's pick the new juror. Oh, wait a minute. I didn't ask my client. I'll be right back. That is absolutely proper to do. About 15 seconds, Mr. Anderson changed his position yet again and announced, I'm going to go with my client. I have to switch positions because my client feels more comfortable with juror number 1. Fine, that's his client's right to feel that way. He's been watching these guys for weeks, and he goes, yeah, I think this guy, I think he's on our side. Let's keep him. There is nothing wrong with that. So I'm going to switch positions based on my client's input. Emphasis added. Yeah, we know he didn't speak in italics. In response, Mr. Kowalski, who advocated to keep juror number 1 on the jury, can be seen turning to Jules and nodding his head with a smile. This exchange is further evidence of an alignment between the plaintiffs and Jules to insinuate a verdict in plaintiff's favor by retaining juror number 1, who, along with his wife, was heavily biased in plaintiff's favor.
Stop it. Every single time that they said that this is ridiculous. We all did the same thing when they retained juror number 1. We all smiled and nodded. Good job, Jack. So this is bullshit.
Yeah. I mean, but this exchange is further evidence. This, just imagine the meme with 3x5 card guy and lots of strings. This exchange is further evidence. So looking and nodding and smiling at two people is further evidence of an alignment between plaintiffs and Jules to insinuate a verdict in plaintiff's favor by retaining juror number 1, who is also sleeping with his wife and is heavily biased in plaintiff's favor. Why can't we say the R word anymore? Because this is clearly R worded. This is just...
I don't know.
All right. What defendants suspected before the verdict, based on juror number 1's question, i.e. a bias in favor of the plaintiffs, warranting his removal as a juror and replacement with an alternative, was demonstrated beyond just a reasonable belief after the verdict. Okay, so what defendant suspected before the verdict was now been proven after the verdict. Specifically, Ms. L was not the only member of the husband and wife pair to engage in public internet posts regarding the case. Following the verdict, juror 1 joined his wife on these public platforms by immediately posting to the Take Care of Maya Facebook group, a plaintiff-favored internet community hotly opposed to any commentary favoring the defense, created in response to the calculated and sensationalized Take Care of Maya Netflix series. He's not a juror anymore. He can go anywhere he fucking wants to go. He can go anywhere. He can say anything. The only thing he really can't say is, "Yep, we fixed this thing, all right." He can say whatever he wants, wherever he wants to say it. Juror 1 quickly posted, "Oh, now that is too funny. Too cool, too," to an AI-generated image of Judge Carroll in battle gear standing in front of a smoking picture of a J-Hatch building. The caption,
have you seen this meme?
Yes, I have.
It's so funny. Oh my God,
I went
his
and
hair, the tuft of justice.
Yes.
Hair.
He has a coif, yes. I went and got the IJ documents myself. The impropriety of an image of the judge presiding over this highly publicized trial, condemning the defense, coupled with the jury foreman's undisguised delight in the image, is additional evidence of juror impropriety and misconduct. Bullshit. A juror laughing at a meme after the trial, after he is no longer a juror.
But he's allowed to be pro-plaintiff because he
funny.
ruled in the favor of the plaintiff. So
obviously, that's evidence of impropriety and misconduct during the trial because he laughed at a meme after.
Did he say palpable?
Oh, did he? Oh my God, he may have.
No,
nope,
God, no.
You're off the hook. You're off the hook. You're off the hook for now. People chat, how? Good question. On November 10th, 2023, we're almost in real time. The day after the verdict was announced, Mrs. L posted a photo of juror number 1 on Take Care of Maya Facebook, thanking everyone who stuck up for juror number 1, presumably referring to defendant's motion to disqualify juror number 1. The same day, juror number 1 posted the following in response. While the other jurors were escorted down to be transported, I was asked to remain in the SCSO by the SCSO lieutenant. Oh boy, I'm in trouble once again, but it was just for some security talk about that. Oops. The oops was the oops they were talking about. Anyway, Juror number one's comment on being in trouble once again indicates that he knew prior to being released from the courthouse that defendant had moved to dismiss him as a juror, a fact he should not have known about if he was abiding by this court's explicit instructions to not discuss this case with anyone or to do any research on the case.
Whoa, whoa, whoa.
No, look,
Who?
when someone says everyone else can go home, but you, Mr. Juror, you stay in class. Everybody's natural instinct is, uh-oh, what did I do? No one's like, okay,
Right.
Lieutenant wants to talk to you and you alone, Mr. Jury. So I'm going, oh, I get a special treat. No, I don't think anyone's thinking that. Do I get ice cream because I'm influential juror number one? No.
But wait, is this after the motion to dismiss the jury? I'm confused.
This is apparently the day before, I think, or just before something. I don't know. I'm not sure. The same day. Yeah, okay. I guess it was like the same day. Anyway, yeah, it was right around that time. They're basically saying he could not have known about the. He was clear when he said, "Oh boy, I'm in trouble." He clearly knew that they were going to try to dismiss him, and the only way he could have done that was if he was having improper communications with his wife, which is just stupid. The fact that juror number one was exposed to information. What information was he exposed to? Prove it. Where is your proof he was exposed to any information? Relating to defense motion to remove him as a juror in violation of this court's instruction is further evidenced by Miss L post thanking the pro-plaintiff Facebook group who stuck up for her husband. Yeah, so if you support someone in a Facebook, that means that you're making sure that he is improperly influencing the jury. Now I'm back. Now the rage. Now we're the meter's back on the rage side. Jewel says this was when the trial was over and the jury was released. Well, I mean, that's when he posted it. But they're talking. He posted it after, but he's talking about when it happened. I believe he's saying, while talking about the day while everybody else was going down, I was asked to remain because I thought I was in trouble. I don't. Anyway, it's still bullshit, regardless of when it happened. That's what we're getting at here.
It doesn't mean anything. No.
See, this is why people like Jules and other people in chat are actually pretty damn awesome, because they remember shit that I would never in a million years remember. I can barely remember what I ate for breakfast, and I clearly can't navigate a court website without Megan's help. And so, I mean, there's a lot of people that are way more invested in trials than me, and even the lawyers involved in the trial. Like the hive mind and the things that's why I always love these things where I'm doing the streams, I'm talking about something, and then I invariably get this didn't happen because on like day 4, at 12:33 p.m. someone said this. I'm like, wow, okay, that's one thing you latched onto that I didn't. Thank you for pointing that out to me, because I can't latch and retain every single thing that's going on, and you get this amazing hive mind that comes together and remembers things and keeps things on track. I love the internet. I think it's a great help to society. Get so many people involved and invested in so many things that they can point out when things happen and when things didn't happen. Why would Judge Carroll even entertain this? Because it was submitted to him. He has to. He doesn't have to agree with it. He doesn't have to grant the motion.
I predict double guns. Denied.
Awesome. To date. Oh, wait. Juror number one continued to post on this plaintiff's favored Facebook group, which hailed him as a hero for being responsible for the verdict against the defendant's hospital. While juror number one made sure to repeatedly express that it was not. Oh, wait a minute. So the Facebook who's saying, "You're our hero, you did it." He's like, "Nah, it wasn't me. I was 1 of 6. So somehow that proves he did something wrong when he said, "No, I didn't." While juror number one made sure to repeatedly express that it was not solely his decision, he seemed to enjoy his newfound notoriety among these online platforms by engaging in posts and videos celebrating him as a hero.
So what?
So? And he's literally saying, "No, I wasn't the hero. I was just 1 of the 6. To date, juror one continues to post about the case, even to the point of advising the internet community regarding filings that will be made on Wednesday, November 22nd. The internet community, in turn, has suggested that juror number one remain humble and quiet out of respect for the process. But a defendant has shown by reference to evidence, juror number one apparently has no respect for the judicial process or for defendant's right to a fair trial before an impartial jury. Trial's over, biatch. You already had your trial, and I think it was fair. If interviewed, see, they're saying we want to interview this guy, but right here they say they know what's going to happen if they do call him for an interview. If interviewed, defendant expects juror one to respond with a self-serving denial of any communications with his wife about the trial. So before they're saying, oh, they couldn't possibly have been in the same house for 9 weeks and not talked about this trial. It strains credulity. And if we bring him in here, he's just going to deny it. His self-serving denial. That's a shitty word to use. Self-serving denial.
So what do they want to do? Put him in a dark cell and pull his fingernails out one by one till he tells them what they want to hear? What is the...
But I mean, just if he denies it, it's self-serving. Not because he didn't do it. It's because it's self-serving. See, you put these argumentative language in here, and I really, really think it devalues your argument even more than it is, which is really hard to do in this instance because it's really devalued. But on Facebook, juror number one loved a comment. A comment by a user praising the fact that his whole family was able to come to court and observe the trial. Oh, shame. In another comment, when a user pointed out that juror number one's wife being in the audience could be a problem for the verdict, juror one laughed at the comment to mock it. As well he should have. He's right. It is laughable. Juror number one.
Laughable. This whole thing is stupid.
The whole damn system's out of order. Juror number one is also liked a comment from the group, which advised him to be careful regarding what questions he asked, as a new trial could be granted if he, quote, says something now that implies he made up his mind. Okay, thanks, commenters in Facebook group. These posts demonstrate that juror number one's bias, which served as a basis for defendant's motion to disqualify, was apparent to the plaintiff's favored online communities that supported juror number one. No, for God's sake, I don't want to break this down, but again, they're saying, oh, because somebody in Facebook said, don't say something that implies you made up your mind, and he likes it. Somehow that proves that he made up his mind beforehand. When they didn't say, don't say, and the chat knew that the chat knew he made up his mind, and they were telling him to be careful so that they didn't figure it out. That's not what they said. They said, don't say something now that implies you made it. They didn't say something now that reveals that you actually had made up your mind already. They're saying to me that says we know you didn't, so don't say something that's going to imply you did.
Pretty much, yeah.
Why else would juror number one need to be careful if he had remained impartial?
I'll tell you why, because everybody knew that you were going to jump down the throats of juror number one. Whatever he did after the motion to disqualify, we all knew you were going to jump down his throat. It's the defense. That's why.
He didn't say, I need to be careful. Some rando commenter on a Facebook group said, be careful. And why did the users worry about juror number one's wife being in the audience? Because they're idiots.
And the only reason why anybody wanted juror number one to be careful was because of the dick defense.
Exactly.
Because they would use anything they could to get a retrial.
Which they're doing.
Clearly.
All right. Now we're getting into LawTube. This is a thing. Speaking of being careful, on November 11th, 2023, juror number one also joined Law and Lumber YouTube live stream, paid the host, known as Rob, $100.
Oh, boy.
And commented that he would be happy to discuss the case with him. Rob, a lawyer himself, appreciating the appearance of impropriety arising out of juror number one's communications, advised juror number one first to consult with plaintiff's counsel before speaking publicly. Juror number one paid Rob $2 in return for the advice, commenting, agreed. Juror number one later removed several of his comments from the Facebook group, evidence that he too realized the appearance of impropriety his actions were demonstrating to the internet community.
There is no impropriety in asking to be interviewed when you're a juror on a big case.
Nope.
The judge literally says, you may talk to the media. You may approach the media. You may approach the attorneys on either side. I don't like, and I argued with Rob publicly about this, so it's not a secret. I didn't like Rob's response. I thought Rob's response to this was dumb. Sorry, but I did. If a juror wants to talk to you, you can say yes or no. But giving him advice to go and talk to plaintiff's attorneys specifically, I think is silly. That attorney is not the juror's attorney. If the juror wants to get his own attorney, he can. Look, I said this on Nick's show. I said, what are you, nuts? Why wouldn't you take the interview? And if you don't want the interview, send him to me. I'll interview him all day long. It's unfortunate that this ended up in here, especially because Rob yelled at me. He yelled at me about, oh, how could you do that? How could you put him at risk? Well, I'm not the one in the motion, sir.
Well, here's the problem. Again, it's like, why is Megan so calm? Did she have too much turkey?
It's the tryptophan from the turkey.
We sedated her before the stream, so it didn't turn into a 12-hour stream. No, but here's my problem with this: is what the Dick defense is trying to do here. That's why we always have these things, and I got to put it up there. That's why we always say nothing in this is considered legal advice. It's entertainment purposes, etc. Because he's trying to turn this into where juror number 1 retained Rob as a lawyer, and Rob was acting as juror number 1's lawyer. That's what they're trying to say with this. You know, how he paid Rob $100.
Oh boy!
Implying a retainer fee of some sort.
I didn't even think about that.
He paid Rob $100, and Rob, a lawyer himself, appreciates a lawyer, processes this legally, considers a possible impropriety, and advises. He gives advice to juror number 1, and juror number 1 paid Rob in return for the advice. So they're saying he paid for his attorney services. So the Dick defense is trying to say that he got legal advice from someone who counseled him to not do to not act in an improper manner. Wow. That's some bullshit. That's some bullshit on the defense's part.
I didn't even notice that, but you're right. They're setting that up.
They tried to set up that for a lawyer-client relationship.
Well, okay.
That's some bullshit. And see what I mean, this is just what I did when it was during the Zachariah Anderson trial, when I found out that people actually watch things. Because I was watching the Zachariah Anderson murder trial, and his brother Solomon at first it was his sister Zenith came in chat and said, I'm his sister. And I'm like, sure. And then she messaged me, and I said, okay, this is going, I better do my vetting. And then I found out, well, her and her brother Solomon had both joined independently, and they were like, oh, hey, you're here too. And and that's when I realized, oh my God, people that are really involved in these things actually watch the trials of their loved ones. They find them on YouTube. And my first instinct, as being me, was like, hey, we got to get you on here. And then I went, well, wait, never mind. That's a dumb thing to do during a trial. Thankfully, I got that out of the way. And then I just messaged her. I messaged her and him and said, look, stay in chat. Stay quiet in chat. Just don't do anything that's going to throw a wrench in the works for anybody. Just, I said, don't send me super chats. Don't engage with me directly. I don't want to say anything or do anything that could compromise the case. And I don't want you to be in that case. If there is anything to say, talk to his lawyers and ask what you should or shouldn't be saying. This was all in a private message because I don't want anything like this happening. But it's out there, and I think they're shitty for what they're doing to try to make this.
All I have to say is if Rob had just said to him, yeah, email me, man. Email me, we'll talk. None of this would be in there. Hey?
Well, no, yeah.
But like waxing all, taking a position so strongly about what this juror should or should not do is really not the place of anybody on YouTube. Like, just.
But it's a coulda, woulda, shoulda at this point.
Yeah, but it could have been avoided. Could have been avoided.
Yeah,
just saying. I would, and I said it on Nick's stream. I'd talk to him. Absolutely.
Yeah, it's ugh, it's unsavory what the Dick defense is doing here, trying to make it look like there's something that there's not. On November
Oh,
19th,
yeah,
short.
for sure. They're
Yeah,
doing that. For sure. And I mean, they're making a big deal out of this is going nowhere. It's going absolutely nowhere. The fact that juror number 1 wanted to be interviewed somewhere and that somewhere said no or wait or whatever. No, he has a right to be interviewed. It's going nowhere. That's nothing.
Ralph 707 Legal Vices doesn't want to take a stand and not choose a side between her and Law and Lumber. No, I was on Megan's side. Didn't you watch the stream?
No,
I
that's not
said
true.
I said
That's
it was
that's
like,
not what he's saying. He's
yeah,
this is an interesting and nuanced conversation,
yeah,
period. I mean, it just is. And that's not what he's saying. And there's no sides.
yeah,
I just disagreed with I
yeah,
still do to this day disagree with Rob's decision not to talk to him or to tell him publicly what he should do. I think that was a silly thing to do. I
yeah,
said that. I've said it on Nick's show. I just thought it was silly. But whatever. I'm
yeah,
allowed. He's allowed. Whatever.
yeah. It's just one of those. It happens. We do these things live, and we react. We say things when it comes up. Yeah, in retrospect, yeah, maybe we don't. Maybe we wish we hadn't done that. But it's out there, and it's not improper. It's
Everybody
just,
likes Runkle because Runkle always sits there and
yeah,
smiles. Runkle never gets in trouble. We should all be more like
yeah.
Ian Runkle.
Or we should all just like gang up on it. That's what I think. We should gang up on it. All right, Mr. No Trouble. You've got trouble now. So yeah, everybody gets their opinion. Anybody can say what they want. There's nothing that's been. We just do things differently, and sometimes we do things we wish we hadn't have done. Sometimes we don't do things that we wish we would have done. And yeah, chips fall where they may. But on back to November 19th. Shortly before the filing this motion, juror number 1 admitted to the Take Care of Maya Facebook group that he had contacted plaintiff's counsel, who advised him that this very motion would be filed. Of course, this is a standard motion. Believe by this Wednesday, defense has to have something filed. Then Judge C has to actually make some reviews and rulings before actually hitting the gavel and closing this phase of the case. So we're listening to counsel as it ain't over yet. So what? What does that prove? All right, whatever. And again, we're more than halfway through this now. Thank God. We're more than halfway through this. We're on for the 4-hour time limit here.
Awesome.
What is the evidence that's been presented in the first 19 pages of this motion to say that juror number 1 did anything inappropriate whatsoever? Nothing. All we've got is he lived with someone who posted about the trial, and so there's no possible
and a whole
way.
bunch of shit about Jules,
Yeah,
which doesn't have anything to do with anything.
yeah. There's no possible way he couldn't have heard about it from his wife. And he talked about it after. None of those things are that is their entire argument when you boil it down. And none of it proves he did everything. They're trying to say that somehow something she did was inappropriate because her husband was on a jury, which is just a non-starter. It's just a non-starter. It's bullshit. November 15th, Law and Lumber hosted plaintiff's expert Dr. Joe Corcoran on his YouTube live stream. Dr. Corcoran spoke about his views at the video and of the then current CEO and then interim CEO of Johns Hopkins All Children's Hospital. That's not what we call it. Should not have been excused in the punitive damages phases, and that if he had not, you can ask juror number 1, that would have put another 0 in the punitive damages. In response, juror number 1 commented that it would have added 14 zeros.
That's funny.
And you know what? You can talk about that all you
say
want.
that.
After trial, outside the jury, outside your jury obligations, he's under no oath, no obligation, nothing. He's completely entitled to say, oh yeah, if I would have known. Well, see, and this also proves the point. He's saying that his wife is feeding him all this information. He's getting all that he has to be hearing all about the trial from his wife. Well, then how come he didn't know about that video? How come he didn't know this
Yeah.
video was excluded?
He didn't know. That's a very good point. He
And that's
didn't know.
and that's apparently such a huge issue. It would have added 14 zeros on it. If his wife is feeding him information, why wouldn't she say, dude, have you seen this video that's out there? There's this video out there. Holy shit. And this is what it says. But he's like, oh, well, okay, yeah. If I would have known about that, I would have added 14 zeros. This is actually, they're actually using this in their motion, and it shows that he wasn't aware of everything that was going.
Yeah, that's evidence. I don't know why they even put that in there. It's not good for their case.
This whole thing isn't good for their case. But in addition to the above improper or not contacts and communications, defense has a reasonable basis to believe that juror number 1 also inappropriately conducted internet research. Okay, so finally they're saying juror number 1 has done something wrong. He's conducted internet research regarding one or more issues in this case, in violation of the court's order not to consider information outside of the evidence presented at trial. Okay, so now we're finally into a something about him. On October 9th, juror number 1 posted the following question. Juror number 1 posted the following. Juror number 1 is doing research, but juror number 1's wife posted the following question to Maya Kowalski. When it comes to creature comforts, were you made to feel comfortable? On October 9th, he posed the following question to Maya Kowalski. Okay, sorry, I was like somewhere else in my head.
It's okay.
All right, got to reboot because all right. Back to focus. I hate when I do that. I short-circuited my brain. On October 9th, juror number 1 posed the following question to Maya Kowalski. When it comes to creature comforts, were you made to feel comfortable? Yeah, this is fucked up. When it comes to creature comforts, were you made to feel comfortable, or were you made to, or just felt that you were in a hostile place? The phrase creature comfort was not used by any witness at trial, but it is used in Dr. Kirkpatrick's RSD Foundation website related to ketamine treatment, as demonstrated below. The treatment, blah, blah, blah. Creature comfort as primary concerns, blah, blah, blah. Who wants to call bullshit on that one?
Total bullshit. I will. Bullshit.
Go ahead.
Creature comforts is a well-known phrase that has been used for my entire existence that I know of. Yeah?
Yes.
It's not an unused phrase. It's not a phrase that no one's heard of. It's not
Like palpable.
Thank God that hasn't come up again. Be on the floor.
Yeah, see, Jules says that that's a lie. The nurse testified on 5th or 6th October. Yes,
Yeah,
one of the nurses used the term. Yeah. There was a witness who used the term creature comforts.
I didn't go back and look, but a lot of people are saying that there was a time when a witness used creature comforts. But whether they did or not, it doesn't matter.
What day did the trial start?
Oh, I don't know the date of the trial.
So what day did the
right, hold on. All right, so it had to have been in my
September 22nd.
Here it is. Okay. So the very first day opening statements were on Maya Kowalski.
Grace says September 22nd.
For fuck's sake, why are
okay? We'll just say September 21st or September 22nd. That's
here.
Good.
Right here, it was. I can tell you the date if this will stop doing what it's doing. Okay, this was 2 months. Oh, it doesn't tell me the date. September 21. September 21st.
Okay, so that's good.
Opening
so 1 week. Yeah, so opening statement starts September 21st. And we have people here saying that the phrase was used on day 5, September 28th, with Rachel DeYoung, Maya's physical therapist. So 7 days after it's stated, that was used. And this was October 9th. So 10 days after that, he uses it. But so what? That was we'll call it a lie because I'm feeling that way today. I would say a misstatement, but we'll call it a lie because they could have checked. They lied about that there. Plus, as you said, it is a common phrase that people use when they're talking about creature comforts.
It's a well-known phrase. It's not obscure in any way. Anybody could come up with that. And just the fact that Dr. Kirkpatrick used it on his website, it's not a novel phrase.
It's
So
not.
you
Not
you
at
could have
all.
heard it anywhere.
Yeah.
This is a stupid, stupid argument.
But see, this tells me that they went through every single thing they could possibly find and did a word search for creature comforts, and this is the best they could come up with.
This is dumb.
But moreover, in videos on his website depicting his treatment of other females of similar age as Maya, Dr. Kirkpatrick often uses the phrases creature comforts when speaking to patients about the circumstances under which ketamine treatment is most effective. So it's the defendant's reasonable belief, based on the foregoing, that juror number 1 visited Dr. Kilpatrick's website to research issues in this case, including with respect to diagnosis and treatment of CRPS in violation of the court's order. That's a pretty ridiculous, reasonable assumption. That's not a reasonable assumption. Finally, it appears, based on a public search of the Sarasota County Court document, if you can find it, that Deborah Salisbury was involved with Ms. L's 2007 domestic relations proceeding. A fact
this
never
is so
disclosed on
dumb.
jury one's jury questionnaire
so
during
dumb.
voir dire.
Because I'm assuming that her domestic dispute thing was with a different man.
It doesn't matter.
Well, he said he didn't know Salisbury. And he probably didn't, because it was
Why would he know it?
Well, if she did retain Deborah Salisbury as an attorney with some other domestic dispute she had in whatever 2007 that didn't involve him, why would he know her? But notice how they don't tell you that it was it had to have been some other man. Even if it weren't, would he have necessarily known the name of her lawyer? I don't know.
I can't tell you the name of my ex-wife's lawyer.
Well, there you go. But they're still married, so it probably wasn't them. It was probably somebody else. Why would she have an attorney involved in a DV or domestic incident with her current husband?
People are saying they weren't together at that time. But
yeah, so it was before they knew one another. So why the hell would he know the name of her lawyer? He probably knows the name of the ex that it happened with, but why would he know who she hired?
And who gives a shit anyway?
No, it's stupid.
It just doesn't matter.
It's stupid.
Similarly, jury 1 denied viewing the Netflix documentary related to this case, Take Care of Maya, on his supplemental juror questionnaire, and denied having any conversation or overhearing any conversations concerning the movie. This seems unlikely.
What?
This seems unlikely because of his wife's heavy engagement, investment, and close monitoring of the case, the court docket.
Do you know how many things I watch on Netflix that my husband has never, ever seen? I watch all kinds of shit on Netflix that he does not know. I have my own profile. He's not seeing the stuff that I watch. He's not watching the stuff that I watch because he's not freaking interested in the stuff that I watch. What the hell?
Yeah. So her watching shit on TV is evidence that he lied, saying he didn't watch it.
Know that most married couples watch TV separately anyway? Do they not know this? That
was one of the things that led to our downfall. We only had one television in the house.
Oh, see, you needed two, and everything would be fine.
So yeah, they're saying that he lied, saying he hadn't seen these because his wife was involved in the trial, so therefore he must have watched them and lied about it. It seems unlikely. Seems unlikely is not a legal standard of review. It seems unlikely, Your Honor. Okay, let's throw out the jury verdict. So stupid.
Unlikely is not a standard of evidence, by the way.
Yeah, it seems unlikely.
Seems unlikely does not hold up in court.
Juror 1's post-trial post to the Take Care of Maya Facebook group further undermine his feigned ignorance of the documentary. His feigned ignorance. Those loaded words, I hate them. They just stand out like a sore thumb. And you go, but how do you know? Evidence of juror misconduct on the part of juror number 1, both individually and arising out of his wife's involvement in the case. This is so misogynist. You're totally correct. social media posts and obvious bias in favor of plaintiffs is substantial, presumptively prejudicial, and compromises the integrity of the verdict, the jury system, and the judicial process as a whole. The evidence gives rise to a reasonable belief that juror number one impermissibly obtained and shared information about the case during the course of the trial with and through his wife, as well as plaintiff's advocate Jules, in violation of this court's instructions and the requirements of Florida law. And because evidence provides a reasonable basis for an inquiry, defendant moves for an interview of juror number one in support of the motion for a new trial, and at the court's discretion for an interview of juror number one's wife. In addition, defendant further requests limited discovery into the issue of juror misconduct in anticipation of the interview, as well as an emergency order requiring jury number one and his wife to preserve text messages, social media activity, and other electronic data, evidence, and communications regarding the trial.
No.
Oof. Yeah, well, it's time to figure out how all this falls into the legal framework.
This is so dumb.
I need another drink of water out of my Legal Vices merch glass.
Now, some people have been saying
Yes.
that there is the spousal privilege, but I think that only is in criminal court.
Yeah.
However, there is a question that if any of this could lead to criminal sanctions or like of perjury or whatever, and maybe
so I mean, that's like theoretically, yes. In deep dark theory, possibly.
Yeah.
But not in any realm of reality.
But the fact that they want to dig through their cell phones just makes me cringe deeply.
Yep.
That's ridiculous.
That's that. Wow, I'm not used to having the sun is pounding through the light here. It's like really overexposed.
I know you're so bright. You're so bright.
I'm so white. I give me 2 seconds here. Hang on real quick.
Okay.
I'm still here. I'm just kind of wandering across the room.
How did he manage to freeze himself on the frame while wandering across the room is the question.
I'm back. I kind of forgot, like the winter sun, just because it's so low on the horizon, just kind of blares through the window because I'm never awake or home during this time of day. All right, we are back, and while we're back, let's cleanse the palate, the palpable palate.
Don't say palpable to me.
You're giving your palpitations.
Uh-huh.
Snuggle struggle. Oh, we have to do the group thank you. We're not going to do the individual bell ringing, so we'll do bye, Megan. That was quick. I assume she'll be back. Let's do the gigantic foghorn thanks to all of the supporters that have sent super chats, done memberships, etc. We're going to read through those. There's 7 of them right now, so let's do the big foghorn as a special thank you. And we'll find out where Megan. Playing devil's advocate says snuggle struggle. Oh, she's back. Hello.
I got kicked out. I don't know why.
I don't either. It was quick.
I don't know.
Snuggle struggle says playing devil's advocate. Have you read anything of substance to this filing that would give the judge reason to actually allow this idiocy to perpetuate? No,
not anything.
Nothing.
And my
Keep up
sister
the good
read
work.
it too. My sister read it too. She
Yeah.
was like, "What?"
Oh yeah, yeah. What did she say? What was her takeaway?
She said she wanted to know what the legal standard was, but we didn't get to that part. But we read the rest of it, and she was like, "There's nothing in here that I can see. This is garbage."
Invite her on.
Though she did say she's not here; she's out. But she did say she thought that it was a bad idea for the juror number one's wife to be doing any of this. But then again, like if they're not given an instruction to not do these things, then it's not okay to hold them to any standard.
Bad idea and improper and wrong are different.
Yeah, different.
I do a lot of things that are bad ideas.
True, but there should be some kind of instruction if this is going to be the standard going forward, that your wife or your husband's going to be subjected to this kind of cyber stalking by a defense team. Well, we should know that going into it then. There should
Mhm.
be instructions for the wives and husbands of jurors. And until that happens, then Ethan
And I can't
Shapiro
imagine
can
that
go
would
fuck
ever
himself.
pass. I can't imagine that would ever pass a First Amendment muster.
No,
So
it wouldn't.
you're a
Because you,
sworn juror, so your
because you,
family and
yeah,
friends. Where do you draw the line? Ah,
right.
Matt Bond. Matt Bond. Did the juror bug one's pillow for pillow talk? Sounds like they want to dig into the pillow here now. A little Barry White champagne court ketchup. Hey, babe, I'm going to go get that motion. The palpable motion coming at you, baby. Get a little Barry.
We were playing Barry White over Thanksgiving. It's funny that should come up.
Oh.
My sister and I were making a cheese ball to Barry White.
Oh, baby, don't you know you're so palpable? You're extremely palpable.
You're the
Anyway.
one. My own.
Ooh. Oh, baby, you know you're the palpable. You're the most palpable of all palpable.
It's
I got
palpable.
baby, it's palpable. I love Barry.
Barry White is the best. That's good music. Good music.
The surefire way to, if I may be so crass, is to say seal the deal with dates. Barry White,
Barry
or
White.
Sade. Barry White and
Yeah,
Sade
Sade.
get the business done.
You know, I miss the 70s. Just saying. It's a good decade. Great music. Good
Moving
fashion.
right along. It is,
All of
yeah.
it.
Joe DiMartino is a new member. Thank you so much, Joe. Deeply, deeply appreciated. McCray with the $5 super chat. Over under on whether Carol dismisses with finger guns. I hope he does. And I hope it's that simple. Your Honor, we'd like to no. I hope that's how long this thing goes. We'd like to make the motion. Are you making the motion? Yeah. This is the motion you're gonna make? Yeah, denied.
Denied.
I hope that's how it goes.
Yeah, and he's gonna pull out the double finger guns. Denied.
And Ellie Fant, if super chats are retainers, then I have a lot of lawyers. Well, I'm not one of them. Don't misunderstand. Nothing I say should ever be considered legal advice unless there's a contract we've drawn up and I'm charging you $400 an hour, which I'm certainly not getting paid here. I just
got a Venmo super chat for me.
That's so awesome.
For being on this stream. Will Call sent me something that said, "Thanks for covering this motion tonight." Well, that was lovely of you.
That's actually very, very kind.
Isn't that sweet?
All right. Well, we've cleared the roster there. Everybody, thank you so much for that. Thank you for the 1,100 people that are here in chat. We've got 683 likes, so we can still have 1,000 likes. Let's see if just for giggles we can get to 1,000 likes. We only need 300 and some math more. 316 more, and we'll get to 1,000. Why not? Just have fun, or 400. I don't know math. Anyhow, let's get back and look at the legal standard. But Will Call Magic, he didn't want me to feel left out too. So thank you, Will Call Magic. Thanks for covering this insidious motion tonight. Megan Fox, your appreciation is venom. It's venom.
Okay, thank you.
That's like Alice Cooper. This girl is venomous poison.
Well, Jules is notorious, so
yeah.
you know.
Yeah. And I'm just a simp, apparently, according to some people out there. Legal standard. Let's look at the legal standard. Sorry, got to sniff there. I'll mute next time. I had to sniff before I could reach the mute button. Apology. Okay. Finally, we take all this bullshit we just read, and we're going to find out what legal standards should be applied to interpret the bullshit we just read. In support of a motion for new trial, Florida Rule of Civil Procedure permits a party to move for a juror interview if the party believes that grounds for legal challenge to a verdict may exist. Okay, we believe there may be grounds to challenge the verdict, so let's interview the juror. Okay, got no problem there so far, but an interview of a juror is proper. So under what conditions can we interview the jurors? Is proper where there is a reasonable basis to believe that a prejudicial act occurred, supporting a legal basis for a new trial, such as improper conduct with a juror or misconduct with a juror.
Improper contact with a juror. which they didn't suggest happened here. Okay.
No. There
Or
needs to be a
misconduct.
reasonable basis to believe that improper conduct occurred or there
Certainly,
was misconduct.
improper contact is not living with your wife,
Surely you are correct.
and we have not established any misconduct. They didn't give us any evidence that juror number 1 did anything. They just whined about his wife
And Jules.
and Jules.
Sorry,
Yeah.
sorry.
Yeah.
A party moving for a juror interview does not have to conclusively establish that the alleged incident occurred. So they don't have to actually prove it happened and actually prejudice this case. They don't have to prove it prejudiced. They don't have to prove it actually occurred in order to interview. But they do have to show there's a reasonable basis to believe that it.
Yeah, I don't see any reasonable basis.
I don't either.
No.
I honestly don't.
0.
In contrast to what is
it might
yes.
be the question, the jury question, but then I read it and I was like, that's it. That's all we all said the same thing. That's not reasonable. Yeah. That was the only thing in the entire motion that I thought maybe this could be something. And then it wasn't. So no.
Well, that's this whole motion. It may have been something, but it wasn't.
It's not. Yeah.
In contrast to what is needed to prove entitlement to a new trial, a party seeking only a juror interview must set forth sworn factual allegations that, if true, would require a trial court to order a new trial. So they have to assert things, but they also have to back them up. We can skip down here a little bit. Should be allowed an opportunity to prove that he's entitled to this contact with a juror during trial about the pending matter, as defendant believes occurred in this case, constitutes presumptively prejudicial juror misconduct. They're saying contact with a juror about the trial. Yes, of course, contact with a juror, talking with them about the trial while it's going on would be presumptively prejudicial, and you'd have to prove why it's not. But where it breaks down is as defendant believes occurred. Is it a reasonable belief? I don't think so. We have to give them the benefit of the doubt until you can actually just show some evidence of their misconduct. Not something that somebody else did that the person may or may not have seen. And the burden shifts. In this regard, once improper contact or juror misconduct is established by juror, so they're jumping the gun here and say, once we establish through the interview that it actually occurred, then the moving party is entitled to a new trial unless the opposing party or unless the plaintiffs can demonstrate that there was no reasonable possibility that misconduct affected the verdict. That's the legal standard. Is there a reasonable belief that these things happened? If so, there's an interview. Does the interview establish the possibility, the reasonable possibility that these things happened? If they did happen, then we get a new trial unless the plaintiff can show that there would be no reasonable possibility that the action was improper, unless they can show that the action would not have prejudiced the verdict. So here's their arguments, and we're almost done, he said. we're not doing, we're actually ahead of schedule. Evidence of juror, they made, I think, 4 or 5 legal arguments. First one, evidence of juror misconduct undermines the integrity of the judicial process and warrants a new trial as a matter of public policy. So evidence of juror misconduct undermines the integrity. Not suggestions of evidence, but anywho, a juror who is biased or prejudiced is not fair-minded and impartial. Oh, I'll let him slide with that. But bias is not judgment. Opinions are not judgment. A juror who is biased or prejudiced is not fair-minded and impartial as required to prevent impairment of the right to a jury trial. The importance of an impartial jury is so fundamental that it is initially scrutinized at the inception of a trial on juror challenges for cause. Did you challenge the juror for cause for a reasonable? You put this juror number 1 on the jury panel, dude. You could have said, I find them to be biased at that point. You didn't. They're on the jury. If there is a basis for any reasonable doubt as to a juror's possession of that state of mind which will enable him to render an impartial verdict, he should be excused. The test for juror competency is whether a juror can lay aside any bias. See, they're saying that bias and prejudice. See, bias right up here. A juror who is biased or prejudiced is not fair-minded. That is not their judgment. That is not does not necessarily mean it. The standard is you can have bias and prejudice, but can you set that aside? Is whether a juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions on the law given by the court. If there's a reasonable doubt about the jury's impartiality, the juror should be dismissed for the case. Evidence of juror misconduct is also evaluated after a jury is seated. Specifically, it is within the trial court's discretion to grant a new trial where it is later suspected that a jury has been tainted based on the basic premise that parties are entitled to a fair trial. Okay, statement of law, nice fact. In Norman, for example, in this case of another case here, the fourth district determined that evidence of conversations between the jury foreman and his brother, who was an agent of the defendant's liability insurer, warranted a new trial, even though the juror testified in a post-trial deposition that no substantive matters concerning the case were discussed. This is an apples and oranges thing to me. This case where they got a new trial was the conversations between a jury foreman and an agent of the defendant's liability insurer. That looks a lot more improper than a guy happens to live with someone who posts on the internet. I just think it's an apples and oranges comparison. And Megan's gone again. Megan, come back. What's happening? Okay. All right. She'll see what's going on. If she comes back, she comes back. If not, there might be internet issues. So let's keep going here. In Norman, for example, we just read that. The fourth district noted that the trial judge has expressly and repeatedly instructed the jury that they were prohibited from discussing the case with third parties in order to prevent outside influence, and had further instructed them not to prematurely form an opinion as to the merits of the case or receive any evidence outside of the courtroom. Notwithstanding the trial court's explicit instructions, the offending juror admittedly engaged in two separate conversations with his brother regarding the case during the 3-day trial. Again, his brother worked for the defendant's insurance. Is that what it was? Yeah, he worked for the defendant's liability insurer. So yeah, that's a little different. The fourth district determined the juror's conversation with his brother continued objective acts that compromised the integrity of the fact-finding process and represented an improper instance of improper contact, which will not be tolerated as a matter of public policy. The court referred to the general rule that potentially harmful misconduct is presumptively prejudicial. That's a general rule. And the contact with a juror during trial about a pending matter falls within this category. Again, there is no evidence that I've seen that there was any actual contact about the trial. He can contact his wife about anything, just not the trial is being discussed. I see no evidence that they've posed in the exhibits or anywhere else that suggests to me that they had any actual contact or conversations about the case itself. Because the record demonstrates that a potentially prejudicial communication occurred and defendant did not dispel the presumption of prejudice, the Norman court determined that the juror's relationship to and conversations with his brother substantially undermined plaintiff's right to a fair trial, compromised the integrity of the jury trial, and thwarted substantial justice. Defendant submits that it too is entitled to a new trial as a matter of public policy. This is Shapiro's or whoever wrote this motion's arguments here. This is their deal. Defendant submits that it too is entitled to a new trial as a matter of public policy based on the undeniable appearance of impropriety arising out of the actions and the conduct of juror number 1 and his wife. In this regard, defendant believes a jury interview will shed additional light on the misconduct. So they want a fishing expedition. They want to call the jury in and try to shed light on additional conduct. I don't think they've showed enough to bring the jury in for an initial interview, let alone enough to interview him about things that they've alleged in the previous 26 pages, plus fish for more. I don't think they're anywhere near that. So they believe that a jury interview will shed additional light on the misconduct demonstrated by this motion and accompanying affidavit. And even if the misconduct is denied as defendant predicts, so yeah, even if he says he didn't do it, neither juror number 1 nor his wife can erase the appearance of impropriety shown by their actions and social media posts. That appearance of impropriety, in turn, presents an independent basis for a new trial. That's their argument. That's all right. Next argument. Defendant is entitled to a juror interview to establish grounds for a legal challenge to the verdict. Defendant submits that it has satisfied the standard for obtaining a juror interview based on juror number one's suspected contacts and communications with his wife regarding the case, presumed receipt of information from outside influences, and apparent internet search during the trial. Again, is it reasonable? Is it reasonable to believe that they're using these words, suspected, presumed? That's the best they can do. And apparent, suspected, presumed, apparent. Are these suspicions, presumptions, and apparitions? Are these reasonable? Have they been is there enough? Have they proven enough to reasonably believe that this may have occurred? A jury interview does not have to conclusively establish misconduct, but only the basis for an inquiry. Evidence of juror number one's suspected bias in favor of plaintiffs, more specifically set forth in defendant's motion to disqualify a juror, has been compounded and confirmed. Has it really, though? Has it been confirmed by unsolicited evidence discovered post-trial involving the heavy social media participation in the trial on the part of juror number one's wife and presumptive agent, Miss L? This presumptive agent thing, no. As well as Ms. L's presence at trial and friendly communication with plaintiff's advocate Jules, it has also been confirmed by juror number one's own social media participation post-trial, which even the internet community has recognized as indicative of jury taint and misphrasing and misconduct. This is such an utter misstatement and twisting of what was said and done. That, I mean, they should kind of be ashamed and embarrassed for themselves how desperate they have to be to try to twist this, because this is such a stretch. As noted, Miss L's social media posts include information she could only have obtained from her husband. We'd totally debunked that. Literally every one of the points we all went through earlier on in this stream with Megan. We all went through and we all said, even all of you in chat said, no, we had exactly the same thoughts, and we've never talked to juror number one or his wife. It's ridiculous. The evidence, therefore, provides a reasonable basis for a defendant to believe that juror one communicated with his wife during the trial regarding the case. In violation of this court's instruction, such communication in turn constitutes presumptively prejudicial misconduct under Florida law. Skipping down here, the record evidence incorporated herein demonstrates that potentially prejudicial communications between juror number one and his wife occurred during the course of the 9-week trial. The defendant does not have to conclusively establish that the misconduct occurred and actually prejudiced his case, but only a basis for inquiry. Snook said, juror number one is alleged to have deliberately disregarded the court's instructions not to discuss the case and to base the verdict solely on evidence presented during trial. Okay, so again, it's an allegation, and I haven't seen any evidence to support that he actually did violate that order. As supported by evidence submitted with this motion. No, and a supporting affidavit. The supporting affidavit from the prosecuting attorney. Juror number one's wife, Ms. L, has not only demonstrated a shocking alignment with an emotional investment in a verdict in favor of plaintiffs, but as the wife of the jury foreman, her conduct threatens the integrity of the judicial process. Defendant, at a minimum, is therefore entitled to interview juror number one to determine the nature and extent of the communications with his wife, with whom he resided during the 9-week trial. Again, he was living with this woman. He was living with his wife, who has an opinion on things. Trial. Ugh. If the social media posts and commentary of Miss L are any indication, these communications have been substantial in direct violation of this court's instruction to the jurors and therefore compromise the integrity of the judicial system and warrant a new trial in this matter. I've given a running analysis to this, so we don't need to go back and rehash that, but I do want to get to some of these very important super chats over here and things. Joe DiMartino, a hit. a very palpable hit. Oh, we need to do the big megaphone, the big foghorn. Thank you for all of the support, people. A hit, a very palpable hit, Hamlet. Act 5, Scene 2. That's actually really good. Baby Gator, me member for 1 month. Thank you so much. I'm beginning to wonder if I'm the wife of juror number 1. It kind of sounds like a lot of people, doesn't it? They're interested in the trial and posting stuff about it and giving super chats to people. Proper. Snuggle struggle. They're trying to prove a double negative here, and it's laughable. The hypocrisy is palpable. It is. And McRae, how much do you think the attorneys have charged over the 7 years of this case compared to the verdict? That plus interest accrued while they drag this out seems really bad, especially with other lawsuits. I would imagine that Johns Hopkins has spent quite a bit of cash on their lawyers, and now they're willing to invest it to try to avoid having to pay any of it to the Kowalskis. And Kristen Russell gets a special. Thank you. It's a special thank you for this amazingly generous super chat. Late to the live, and yes, I'm off topic, but can I get some good vibes and juju for my dog Ruby? We're running in a national qualifying stock dog trail on Sunday. So if we could get a toast and everyone could wear red, thanks, that would be awesome. Oh, I don't have anything red to wear to toast with. We will do this quickly here. Quickly drink my lemon water. I'm sorry, lime water. All right, we will do this for Kristen Russell. Kristen Russell, may your dog run like no other dog has ever run before. Like the hounds of hell. Whatever you do, please. Release the hounds. Cheers. And wear red. Ruby red. Red for Ruby. Thank you so much for that generous super chat. And I hope your dog does amazingly well. Ooh, that was warm and fuzzy. Thank you so much. Deeply, deeply appreciate it. All right, let's see how much more of this we can put up with. We're nearing the end. We're in the final trimester. You are so welcome, Kristen. You are so welcome. Run, doggy, run. Right. I just check one thing here real quick. Right, done. Defendant is entitled to a new trial if the juror interview establishes improper contact. So they're trying to establish that they have grounds to actually talk to the guy. And then once they talk to the guy, they want to fish for more information. And then if they fish for more information, they're hoping that establishes that there were actually improper contacts and communications between juror 1. Defendant believes it will establish improper contacts and communications between juror number 1 and his wife during the trial or other jury misconduct, such as improper internet research by juror interview. If so, defendant will be entitled to a new trial as a matter of law, unless plaintiffs can demonstrate there is no reasonable possibility that the juror misconduct affected the verdict. In the face of substantial evidence of presumptively prejudicial juror misconduct, culminating in an exorbitant verdict awarding plaintiffs every dollar requested on every count of their complaint, which itself should shock the court's judicial conscience, defendant submits that it will be impossible for plaintiffs to satisfy their burden, demonstrating no reasonable possibility that the jury misconduct affected the verdict. Not surprising, that's an overwrought sentence, isn't it? Ugh. Not surprisingly, I've been saying ugh a lot reading this, haven't I? But that's just my feeling. I'm either going to be saying ugh or I'm going to be cursing. Ugh. Curse. Got to get the cursey words in there because they're close to coming out. Not surprisingly, defendant has not located a reported decision revealing the extent of social media participation and blatant bias exhibited in this case. Okay, so they're saying we haven't been able to find a case that talks about this. The 5th District noted that jurors who tweet, blog, and surf, jurors who tweet, blog, and surf continued to disrupt and derail lengthy trials, resulting in mistrials and unnecessary waste of public and private resources. Jurors who tweet, not jurors' wives who tweet, jurors' children who tweet, jurors' friends who tweet, not jurors who are no longer jurors because the trial's over tweet, jurors who tweet. That has nothing to do with this, literally nothing to do with this case, but they threw it in there anyway because that's the best they could come up with. But this motion does not involve a mere instance of tweeting or blogging or alleged juror misconduct arising from the use of social media during a trial. That case they cited from jurors who tweet. Rather, the evidence presented reveals a shocking and pervasive use of social media by the spouse of a jury. Four-person. Doesn't matter if they're the four-person. Doesn't matter if they're rando juror number 5. Juror number 5. It doesn't matter. Juror is a juror is a juror is a juror. And these use of social media, shocking and pervasive use of social media by the spouse of a jury. That means nothing. She is, I know we've said this 8,000 times. She is not under any restriction to what to say, post, do, or anything about this. She didn't take the juror's oath. Her husband. Okay, now the humor meter's back now squarely in the rage zone. So sorry for the rants. I just vented. I just vented my spleen. I was just coming back to a happy place again when I'm presented with the next sentence. With the next part of this sentence. We got as far as rather the evidence presented reveals a shocking and pervasive use of social media by a spouse of a jury foreperson, and I calmed down. Then we got to the with whom the juror resided during the course of a 9-week trial. Back to that again. Accompanied by a highly improper and pervasive bias in plaintiff's favor. The evidence also reveals juror number 1's participation in the same social media activity post-trial, demonstrating a shared bias in plaintiff's favor. He didn't show any of this bias before, during the trial, or he would have been off the jury. They tried, they didn't get him off. What he does after is his own goddamn business. Ms. L, as juror number 1's wife, should have displayed an extra level of respect for the judicial process. We are butthurt that the wife of a juror is exercising her First Amendment rights, and she's disrespecting the judicial process. So effing what, brah? Bro, be butthurt. Why should juror number 1's wife have an extra level of respect for the process? Why, what makes her so special? Nothing. She is every person. She's a free woman. She's allowed to have opinions. That's how this thing works in modern society. Women are allowed to have opinions and post on it. She is under no oath, no injunction, no instruction whatsoever to not do what she did. Was it smart? I don't know. Was it wrong? No, not in any way that I can see. If only to avoid any appearance of impropriety arising out of her role as the wife of the jury foreman. But instead, she incessantly and publicly posted inside information on social media about the trial she could only have obtained from her husband, which we've already said is bullshit. In clear contrast with Murphy, the other case, the circumstances at issue have substantially undermined defendants' right to a fair trial, compromised the integrity of the judicial system, and thwarted substantial justice, warranting a new trial. Indeed, while defendant has not located a Florida state court decision with analogous facts, probably because there isn't a case, probably because people realize that jurors' wives can talk about whatever the hell they want to talk about, and nobody's ever been dumb enough to try to set aside a trial result based on something that a juror's wife posted somewhere. Maybe that's why there's not a Florida state case with facts. Likely because the egregious and therefore uncommon nature of the misconduct at issue, or it's so protected by the First Amendment that you should just shut up right now, unless you really have some good evidence that there actually was misconduct. Other courts have condemned the type of intra-family communications between jurors and their spouses or other family members that appear to have occurred in this case. Appear to have occurred. They can't say did occur. They can only say appeared to occur in this case, even without evidence of actual prejudice. In U.S. v. Gaffney, for example, the district court acknowledged that extraneous influences demonstrating the existence of partiality or bias may be shown by communications other contact between jurors and third persons. The Gaffney court noted that third-party contacts with jurors, once proven by a defendant, creates a presumption of prejudice and shifts the burden to rebut such prejudice to the opponent, acknowledging that the failure to negate the presumed prejudice results in a new trial. That's a mouthful, but it's basically what they've already been saying. Once you prove that this happened, then it's presumptively prejudicial, and the other party has to prove that it wouldn't have affected the results. We don't care about the Gaffney case. Skip down through that. There's another case, Stauffer v. Trammell. The 10th Circuit concluded that evidence of nonverbal communications between a juror and a juror's spouse was improper, warranting an evidentiary hearing. A trial witness in Stauffer, in this case, testified to observing repeated nonverbal communication between juror Vetter and her husband, including looking at her husband with a questioned look in her face, and her husband responding by nodding and rolling his eyes. Yeah, that would be improper to do in court. If juror number one's wife was back there going, and he's going, yeah, we've got a much better argument. But there's nothing to do with anything that's been alleged in this. The witness explained that the juror had given her husband the questioned look in response to a strong point by the prosecutor. Although the district court concluded that the defense had produced nothing more than speculation and denied the defendant's request to examine the juror, the 10th Circuit reversed, noting that the timing and context of the Vetter's nonverbal communications and the witness's specific observations strongly indicate the Vetters were discussing matters pending before the jury. And the 10th Circuit concluded that this is improper juror communication. The state court erred in failing to allow a hearing to investigate it, characterizing as implausible the argument that the Vetters' communication did not favor either side. Notably, the 10th Circuit in Stauffer rejected the argument that a hearing was not necessary, so they got their hearing in that case. The 10th Circuit considered the juror's credibility, determining that the witness's testimony regarding the nonverbal communications constituted improper jury communications. They quote another case, State v. Perry. Court similarly determined that juror misconduct had occurred as a result of expressions of bias against the defendant on the part of a juror's husband, requiring a new trial, even though the misconduct probably did not alter the results of the trial. Evidence was presented that the juror's husband had expressed his disdain for the defendant and hope of an indictment to a witness for the state, telling the witness he had talked to his wife, who had already decided he's guilty and was just waiting to hear your testimony. See what they've done here? You go, oh my God, the court determined that someone expressed their bias against the defendant. A juror's husband said that, well, that sounds like this case, where the juror's wife is expressing bias against the defendant. Well, this sounds like it. Oh my God. But then you read that the husband was telling witnesses he talked to the juror who had already decided he's guilty and was just waiting to hear your testimony. None of that happened in this case. Again, yeah, if the juror did say, if juror number one's wife said, yeah, I talked to my husband and he during the trial, I talked to him during the trial, and he already made up his mind before whoever testified, and he was just waiting for someone to testify so he could shut the book on you guys. Yeah, that's improper. None of that happened here. None of that happened. When subsequently questioned regarding a statement, the juror's husband said that he was just running off at the mouth and did not, in fact, talk to his wife. Well, you've given the appearance that you had. That hasn't been done. There's nothing to say that anybody was running off at the mouth to either one of them in this case. So I think that is a total apples and oranges comparison. They just keep repeating the same stuff. Communications aren't harmless, blah, blah, blah. Under the circumstances, it strains credulity. This is what they said earlier at the beginning. Under the circumstances, it strains credulity to believe that Mrs. L and her husband, juror number 1, did not discuss the case during the 9-week trial. To the contrary, the contents of Miss L's social media post reveal inside information. No, it doesn't. That I can see. She could only have discovered from her husband. We all discovered it from other places other than her husband. Her heavy emotional involvement in the trial and in the verdict in plaintiff's favor is further evidence of a shared bias. Her involvement shows that he is biased. The fuck does that even mean? How can you, with a straight face, type that onto a document? Her involvement in the case is evidence of shared bias on the part of her husband. I'm at a loss for that one. McCrae says, Legal Vices, what is the correct site for the docket? You'll have to ask Megan Fox. I don't know. I couldn't find it, so I had to have Megan send me this document because I'm not smart. The 12th, I think it's the 12th Circuit, whichever the Sarasota County clerk, the Sarasota County Court website. I was apparently on the wrong one. I don't know where the right one is. I got this from Medium Smart Megan Fox, but I don't know what that makes me, but hey. Thanks, Megan. The circumstantial evidence gave rise, his wife together formulated a shared bias in favor of the plaintiff during the trial. Discussed that bias and the case throughout the trial. So because she's heavily involved in this, that means they talked about this case through the entire process, resulting in presumptively prejudicial misconduct, undermining the integrity of the process, and warranting a new trial. Defendant therefore requests a juror interview in order to establish the existence of presumptively prejudicial communications between juror number 1 and Mrs. L. They want a juror interview. Although such communications surely will be denied. Yes, of course, they're going to say, no, we didn't do it. Probably because they didn't. This court, like other courts in Stauffer and Perry, have discretion to assess the L's credibility under the circumstances and to rely instead on the evidence of its totality. Moreover, assuming such communications are established, big assumption, assuming that they were able to establish that these communications actually took place. Big assumption. Assuming that's possible, though, assuming they do that, assuming such communications are established, defendant further submits that it will be impossible for plaintiffs to prove there is no reasonable possibility that juror misconduct affected the verdict. Accordingly, defendant submits it has satisfied the standard for entitlement to a juror interview, and that its entitlement to a new trial will be established once the request for a juror interview is conducted. Now they want to get into all their private stuff. Juror number 1 and his wife should be ordered to preserve all text messages, social media activity, and other electronic data evidencing communications regarding the trial. They want to dig into their private bits here. Now let's do these 3 super chats here, and then we'll get into the final argument. We are in the home stretch here. Matt Bond. Oh, we got to give everybody the big foghorn. Thank you so much for the support that you and others have shown throughout the night. This is fantastic. Love you guys. Matt Bond, the motion is higher on the pain scale than CRPS. It's certainly way up there on the I can't believe this got typed out on a piece of paper level. Jason Smith, the $10. Thank you so much. If you had told me a week ago that my meme would end up detailed as a point of contention in the defense's motion for a new trial, I would have made a meme of you saying that, but here we are. You can't make these things up, Jason Smith. Snuggle Struggle with the $20 super chat. Thank you so much. Due to the epidemic, what epidemic? The number 1 cause of death in the United States is medical malpractice, surpassing heart disease and cancer. In Wisconsin, Grace Scara v. Ascension St. Elizabeth Hospital, medical battery. Please cover this one. I'm unfamiliar with the case. It says it's weird. It's weird being famous. Thank you so much, Snuggle Struggle. And thank you so much, Jason Smith. And there we go. Let's pull this off. All right. We are in the home stretch here. 979 of you have stuck around for, what is this? 3 hours and 5 minutes. We should be done here pretty quickly. So hang on in there to the end because we're getting to this. What I won't do is read the new 100-page motion that they filed. There's another 100-page motion out there that the defense filed. We're not going to get to that. Juror number 1 and his wife should be ordered to preserve all text messages, social media activity, and other electronic data evidencing communications regarding the trial. Defendant has learned that individuals associated with juror number 1 and his wife have begun deleting social media posts and presumably text messages upon the belated realization that Mrs. L are participants in juror misconduct. Oh, along with juror number 1. Any such, I'm not even going to dignify that shit with any type of. Any such spoliation of evidence on part of juror number 1 and his wife will necessarily undermine defendant's ability to provide the court with a complete record of the misconduct set forth herein. Defendant therefore requests, here's what they're asking for, the entry of an emergency order precluding juror number 1 and his wife from deleting text messages, social media activity, and any other forms of electronic data pertaining to the case, pending the requested juror review. And they're saying here's some cases where it allows you to use emergency motions to do this. Entire browser history, that her selective deletion of certain text messages demonstrated a consciousness that she had engaged in misconduct. This is from the other case. Defendant further requests limited discovery into the referenced communications and electronic data in preparation for the requested juror interview. So they want these things taken down. They want discovery. They want to crawl into their private bits, and they want to get some additional information even before they interview them to see whether they should be allowed to do it. In conclusion, we are at the conclusion here, peeps. We have arrived at the conclusion. Circumstantial evidence creating an appearance of juror misconduct undermines the integrity of the judicial process and warrants a new trial under Florida law as a matter of public policy. A more compelling case of juror misconduct than the one presented by this motion can hardly be imagined. If you can't imagine a case where there's been more judicial misconduct than this one, you, sir, have the worst imagination on planet Earth. I can think of like a dozen right off just like instantly. I have images from a dozen things that could be worse juror misconduct flashing in my mind. So again, this hyperbole really, people use hyperbolic language like this when they can't actually persuade you with normal words. When you have no arguments to make, when you have no evidence to throw, you have to use this hyperbolic language to try to shock people into coming to your side. I mean, that is such a ridiculous statement. A more compelling case of juror misconduct than this one can hardly be imagined. That's some bullshit you say when you really don't believe your own argument. Defendant suspected juror number 1 of a bias in favor of plaintiffs before the jury began their deliberations, and therefore moved to disqualify juror number 1 to replace him with an alternate. And it didn't work. The judge didn't find that, did he? There was nothing found. Juror is still on the jury. Defendant, deferring to his client. Why is client in quotation marks? He was his client. Why is client in like, yeah, his client, if you can call his client that, he was his client. Deferring to his client, Jack Kowalski predictably chose to allow juror number 1 to remain, acknowledging his victory with a smile to his TikTok advocate, Jules. Jules, if you do not have merch that says TikTok advocate on it, I know it's way too soon, but after this is over, that would be funny. TikTok advocate Jules, who developed a friendship at trial with juror number 1's wife, Ms. L's social media posts and commentary in turn revealed not only Megan's not here. Megan, if you're watching, take a drink. not only a palpable bias and prejudice in plaintiff's favor, but inside information she only could have obtained from her husband, juror number 1. The L's reside together in the same household. Back again with this living together stuff. She's living with a juror. Together in the same household for the course of the entire 9-week trial. It strains credulity. That's the third time they've used that ridiculous phrase. It strains credulity to believe that the L's were not sharing information regarding the case, particularly given the nature of their social media participation. He didn't have any participation that I can see. Melanie, Megan has the 100-page document. I have the 100-page document because Megan had the 100-page document. I don't know where to get the 100-page document. Yeah, so Megan may want to do, but they're going to have a hearing on this on Monday. There's going to be a hearing on this motion on Monday. So we'll have to see how it goes. I don't know if it's in the afternoon, apparently. Don't know if it's going to be streamed. We'll find out what happens. Because we have inside sources. People close to the case physically appearing in court. Probably. All right. Let's continue. Defendant does not have to prove actual misconduct to be entitled to a juror interview under Florida law. Rather, defendant only has to establish a reasonable belief that misconduct occurred to be entitled to interview a juror regarding the presumed misconduct. So if you have a reasonable belief there was misconduct, you get to interview a juror. And then if you establish, once juror misconduct is established, or if, I think we should say if juror misconduct is established, a new trial is warranted unless the non-moving party, which would be the plaintiffs in this case. So if juror misconduct is established, a new trial is warranted unless the plaintiffs can establish beyond a reasonable possibility that juror misconduct did not affect the verdict. Defendant has more than satisfied his burden of proof. No, you haven't. You have not. No, you haven't. Defendant has more than satisfied his burden of proof on this entitlement to a juror interview under Florida law. And if you have, I mean, I can somehow in my mind conceive of them going, okay, let's bring juror number 1 into interview. I can see maybe meeting the threshold. I don't think they have, but I can see them maybe meeting the threshold to interview juror number 1. But I can't see any way this would lead reasonably to a new trial. So they say defendant more than satisfied his burden of proof to entitlement to a jury interview under Florida law. Defendant therefore requests the court order an interview of juror number 1, and in the court's discretion of his wife, Yolanda L., regarding the communications and contacts alleged herein and in the affidavit accompanying this motion. Defendant further requests the entry of an emergency order requiring the L's to preserve text messages, social media activity, and other electronic data evidencing other electronic data. That's kind of vague to me, but whatever. Evidencing communications regarding the trial pending the interview. Finally, defendant requests limited discovery regarding the issue set forth herein in preparation for the requested jury. Wherefore, defendant Johns Hopkins All Children's Hospital, Inc. moves this court for an order permitting defendant to interview juror number 1 and his wife, L, regarding the evidence discussed herein, opening discovery into further evidence of juror misconduct, and requiring jury number 1 and his wife to preserve all text messages, social media posts, and other forms of electronic data pertaining to this trial on an emergency basis, signed, sealed, deliver, and filed with the court. That, ladies and gentlemen, is the entirety of the 40-page motion. Not going to even look at the 100-page motion. So, I mean, Megan had to leave for her reasons. But while she was here, and since she's been gone, anyway, we've seen what we think of this. And I normally try not to watch what other lawyers on YouTube say about things that I'm going to talk about, because I don't want to be biased by what they're telling me. I want to see it for myself, and then I usually go back and watch. But Jules, who filed a 100-page motion? The defense. They filed an additional 100-page motion, apparently. So yeah, I try not to watch them because I don't want to be biased. But I've seen the thumbnails and I've seen the video heading. So yeah. I think pretty much everyone else agrees with me. So well, I'm gonna go back and watch and see what the other people thought about it. But I mean, I don't think there's any. It's just these. The motion is laughable. It's it's nothing about what juror number one did. It's all about his wife's social media presence and her friendships with people physically appeared in court, people that sat next to other people. Might have got to know them a little bit after 9 weeks of sitting next to people. I don't think. I mean, we'll have to see. Motion hearing on Monday. I it's it's so frustrating. I mean, they have to do it. They have to do their job as lawyers and try to get this thing overturned. But the way they're doing it, this is just so bad. It looks bad. It makes people hate them even more. It is desperate, McRae. It's absolutely desperate. It's desperation, and that's what you got to go with sometimes. 140 pages to be responded to in 3 days. Well, people don't get a lot of sleep. There's armies of lawyers working on it from both sides, I'm sure. Well, at what point does a filing become frivolous? I mean, there's various standards, but I mean, basically, if there's just if there's just looking on the face of the application, the face of the lawsuit, whatever, if there's absolutely just literally, there's no conceivable way that any of this is a thing, then it would be a frivolous lawsuit or filing. But I mean, there's like, well, I was going to say there's a wisp of smoke in this one, not necessarily a fire. There's a wisp of smoke, but I will say that I have to expand that a little bit because that's not accurate. I don't think there's not even a wisp of smoke yet that I can see that juror number one did anything. What I'll say is we're in a campground and there's a hint of smoke. There's a wisp of smoke coming from the next campsite's campfire. So that's all we've got, and we'll see how this goes on Monday if the hearing is on this, which I understand it is. Oh, Kurt is like Mikey. He's the skeptic, and he got it right, so we know we're right. So Kurt feels that way. I know other people seem to feel that way from their thumbnails and whatnot. All right, well that gets to the end. Now we wait and see. We see the hearings if we're allowed to. We see how the judge rules on this. I don't know if there's going to be any cameras in the hearing. I would suspect there is because this is a big deal. I would suspect there's going to be, but if not, we'll find out about it one way or another. Right, it's a waiting game at this point, folks. I do want to give some serious thanks for everybody that stuck here for the 3 hours and 19 minutes of this. It's a longish stream today. 963 of you currently here. We got 833 likes. If you want to boost those likes before we wrap this up in the next couple of minutes, please feel free. And any of you that have not subscribed, have even the slightest interest or inkling of doing so, I would greatly appreciate it. We do stuff like this here. We do trials, we do trial coverage, we do social issues, we do things, we do retrospectives. Just a little bit of a future plan. Every Monday we do Maritime Monday. We're talking about a a case called the Wager from the 1700s that involves murder, mutiny, cannibalism, and other unpleasantries. Tuesday, we'll probably be doing a YNW Melly murder retrial update. Wednesday, probably going to be looking into some Alex Murdoch things. There's been some big developments in the Alex Murdoch case, including the arrest of Betty Hill, the clerk of court's son, on wiretapping charges. And hours, maybe a day before or hours before he was arrested, she had to turn over her cell phone reported to the authorities. So something's going on there. We'll try to get some updates. And every Thursday we do a retro trial. Right now we're just getting ready to wrap up the O.J. Simpson trial. Next Thursday we're going to be watching the O.J. Simpson trial closing arguments. And when we finish with that, we're going to be watching a brand new older trial retrospective. We'll announce it at that point in time. And next Friday, I don't know, we'll do something fun. So those are kind of some of the things we talk about here on the stream. So if you're inclined to give a subscription, please subscribe to the channel. It's free. It doesn't cost you nothing, and it makes me happy. You might accidentally enjoy it. All right, clear off the final super chat of the night from Allegan News. Does this court have jurisdiction over the wife? Could they force her interview or force preservation? Yeah, they're in the jurisdiction, I guess. I guess they live there, so they are within the court's jurisdiction, and it isn't within the court's discretion, according to the case law that the defense cited, that the court can do it. But who knows? Who knows what's going on in this ridiculous trial? The Dick defense, I don't think is going to win. I don't like to predict these things. But I'm feeling comfortable about this one. All right, folks. On that note, thank you, mods, for being here. Thank you for taking time out of your day, your night. For some of you, your very early mornings, Alan. Looking at you to be here, to do this, to hang out with Megan and me as we read through this laughable, frustrating, palpable emotional motion. Thank you, mods, for being here. Chat, you guys have been fantastic. You're always fantastic. You're all part of the Vice Squad now. All the Vice Squad members are the greatest chat on the entire internet. Thank you for your love, your kindness, your support. Thank you for I love that when I get a chance to read what's going on in the chat. On these big reading streams, I like to go back later when I'm able to and read what you guys were talking about. You guys are hilarious. I love reading the chat. Thanks, guys. Thanks, people. We'll see you on Monday for Maritime and possible updates. This case. So check out Megan Fox over, Megan Fox's YouTube channel. I'm sure most of you are subscribed to her or know of her. Megan Fox. We'll put her link down here in the chat here in just a bit. I mean, in the description. We'll see y'all on Monday. For the rest of the weekend, whoever you are, wherever you are, whatever you're doing, always make sure you are enjoying legal devices.